Your Lordship, may I mention that Your Lordship's writ petition 21406 of 2024, as last order, it was supposed to be listed today, however, it's not shown in the cause list. It may be listed on 29/8, the senior has to.
Yeah.
Petitioner is also appearing on it.
My lords, kindly list it on 29, my lords. No matter not to be deleted.
No, it will come.
My lords, obliged.
You want it 29th.
August.
29th August, my lords.
Who is to argue the matter?
The-
Who is to argue the matter?
is senior advocate Sarjan Puaya for the opposite party number 4, and for petitioner is senior
Sanjay.
advocate Sanjay Seth.
Here.
See, this was filed challenging the order of central administration, and in the past date, improved order was stayed. But in the latter dates, it was not extended. My lord, for the extension of
The matter is not laid in this bench, my lord. Your lordship last disposed the matter along with Justice Savitri Rath, my lord. I filed a prescription for modification order.
Madam, you are questioning, madam, you are questioning. You should not date for this. Rather, ଲେଖିଛନ୍ତି ଦି ଜଣ ଜଜ୍ ଙ୍କ ନାଁ ଲେଖିଛନ୍ତି ରଖିତ ତାଙ୍କୁ ଠିକ yes next
2015 matter, man.
on pen
The service matter. Last listed in the 2024. Not yet listed. Last listed on 2024. 25/11/2024.
what is the prayer in that petition? Have you gone through that?
Challenge the order of 15/9/2015.
What is that order?
The August.
What is the order?
So, not gone.
Why is not gone? Then come tomorrow and make amends. Day after tomorrow.
Yes, ma'am.
At least go through the file, know the prayer. Yeah, yes.
For admission serial number 23825, appellant custody more than 10 years.
Please give it.
Serial number 18320, same appellant custody more than.
Bail matters. You give all these memos.
Matters of the criminal case.
Instead of one month, what do you do? That's what I see.
Supply list item number 1.
That done 15/4/2025 in course of hearing, your lordship directed me to submit the trial court records, my lord. I have already submitted all those records. That is also available in file, lord, of the in the file, lord. Lord, this is a matter where the I am challenging the order of Prominent Central Administrative
Who is
Tribunal.
appearing for the,
But I am there for it.
which order you are challenging?
Lord, I am challenging order that says Section 1 2020.
No, annexure you tell me.
Annexure 16/63, my lord. This is a case, like,
This is of the year 2020.
lord,
What was your prayer before the Learned Central Administrative Tribunal?
to pass the order of dismissal, my lord. That order of dismissal is at Annexure 12, page 38, my lord.
And what order was passed by the,
Central Administrative Tribunal dismissed my original application, my lord, because this order was passed invoking the Article 311 2C of the Constitution of India, my lord. Honorable President of India has passed the order, and that was asserted by me before the Learned Central Administrative Tribunal.
Come to the operating part, page 75,
Page 75.
Para 60.
Paragraph 60. my lord.
ready.
We have considered the rival submissions in threadbare. Admittedly, the applicant was a senior officer handling personal issues relating to ARC personnel base in Charbatia. He is direct in a criminal activity like illegal trafficking of women and their sexual exploitation as part of an organized criminal racket is undoubtedly an unbecoming on the part of the government servant. The applicant is also well aware of the preamble of the Intelligence Organization Restriction of Right Act 1985, providing restriction of certain rights conferred by the Part 3 of the Constitution the members of the certain organization established by the central government for purpose of intelligence or counter intelligence so as to ensure the proper discharge of their duties and maintenance of discipline. It is an admitted fact that on 16/12/2016 an FIR was against the applicant by the ACP such and such airport zone to for applicants involvement of offences under section 370 such 370B2 120B 34 IPC read with section 345B 5C 79 of the Immoral Traffic Prevention Act 1956. And this being the subject matter of the Bagwit PS case number such and such, the applicant was arrested and remanded to the jail custody and subsequently released on bail on 23/12/2016. From the above, it is clear enough that the applicant, being a responsible officer of an organization which has a formidable role concerning security protection of the country, the potentiality of the above act on the part of the applicant being prejudicial interest of the sovereignty and integrity of the country cannot be dispelled because the applicant is a responsible officer of an intelligence organization and there is every likelihood of the security being vulnerable in case applicant is allowed to continue in organization. In such an eventuality, there was every reason for the respondents to do away with the departmental inquiry under the relevant rules of CCA rules 1965, and to this context, they have not acted divorce the rules as the issue is answered. Last but not in the least, we have gone through the report of the committee shown by the respondents during hearing of the OA, and upon perusal of the same, we found the reasons recorded for dispensing with the regular inquiry under CCA rules are wholesome. Lord, this is the allegation starts, Lord, Annexure 1 on the basis of
when the integrity and sovereignty of the country is at question, even the fundamental right under chapter 3 of the constitution is not available.
Yes, my lord. But before taking such a decision, my lord, some material must be with the authority that for taking that decision. And
Is it
here, my
not a
lord,
case where charge sheet has been submitted against you? Is it not a case that charge sheet has been submitted against you? So prima facie material have been found by after completion of investigation, right?
Yes.
So they need not wait till ultimately suppose you go scot free. The matter is different, but
Yes.
now when the you are involved in such type of offense,
my lord,
Immoral Traffic Prevention Act offenses, and in which after completion of investigation charge sheet has been, so what is the stage of that case now?
that case is, that evidence is going on. My humble submission, my lord, so far as criminal case is concerned, whether I will be penalized or not, that is another different matter.
You are correct. If you are correct, if you would not have been working in this organization, in the ordinary parlance, if you would have working somewhere else, your argument may hold water. But in so far as the nature of job you are assigned in the intelligence department, where the sovereignty of the country is in question, this technical argument that the inquiry cannot be dispensed with may not hold water.
My humble submission, while taking the decision, the authority has to take into consideration all other aspects. And while taking in the decision by the learned tribunal also, they have to go through the material placed before the learned tribunal.
You come to what they have, there is counter affidavit.
Yes, ma'am.
Come to paragraph.
Paragraph 6 and 7 both are their stand. Page 67.
Please.
Milord, opposing the relief sought by the applicant, the respondents have filed a detailed counter. According to the respondent, the applicant was senior most officer handling personal issues relating to ARC personal base in Charbatia. His direct involvement in a criminal activity concerning.
Just 1 minute.
1 minute, I'll just.
That is, that includes
Yes,
judgment
67.
is there. 63 to
Nothing that
76.
is-
Just,
The reading judgment.
oh, there's no.
67.
60,
Okay, I got it.
which order under challenge is annexure 16.
Yes. Internal page
Page
5.
wait,
Yes.
annexure 16.
Page
And,
60.
Page, it is, page number What is it?
67.
Paragraph number 6.
Yes,
That is page number 67.
Yes,
Right,
yes.
you got it.
yes, I got.
Paragraph 6.
Read it out once again.
Yes, sir. Opposing the relief sought by the applicant, the respondents have filed a detailed counter. According to the respondent, the applicant was the senior most officer handling the personal issues relating to ARC personnel base in Charbatia. His direct involvement in a criminal activity concerning illegal trafficking of women and sexual exploitation as part of the organized criminal racket is clearly unbecoming on the part of the government servant and potential affecting national security. Respondents have pointed out that, respondents have pointed out that the preamble of Intelligence Organization Restriction of Rights Act 1985 states that Act is to provide for the restriction of certain rights conferred by the Article 3 to Part 3 of the Constitution for derogation to the members of certain rights conferred by the Part 3 of the Constitution in their application to the members of certain organization established by the central government for purpose of intelligence or counterintelligence so as to ensure the proper discharge of their duties and maintenance of discipline among them. In paragraph 20 of the counter reply, the respondent have averred as follows. Article 33, they have not quoted. Then you may kindly turn to paragraph 7. Respondents have pointed out that from the details of the FIR laws against the applicant and the secret information received obtained in the department, it is clear that he has part of the criminal conspiracy and involved in a criminal racket relating to immoral trafficking of women and prostitution. Further, it has been submitted that at the time of incident, the applicant was holding the rank of Assistant Director Personnel, a Class 1 post in the Government of India. Being the Personnel Department of ARC, he is fully aware that Aviation Research Center ARC is an intelligence organization, Government of India, as well as the Intelligence Organization Restriction Rights Act 1985. Respondents have submitted that the case was thoroughly examined in the department and as per the procedure contained in OM number such and such, a proposal was forwarded to the DOPT for placing the matter before the advisory committee for taking action against the applicant under class C of the proviso 311(2) of the Constitution. The recommendation of the advisory committee was placed before the competent authority, and with the approval of the competent authority, the applicant had order dated 15/2/2000 dismissed from service without any pensionary benefit or compassionate allowance. Consequent to such dismissal from the service, therefore, respondent have prayed that the weight being devoid of merit and liable to be dismissed. My humble submission, in their counter, they have taken, they have harping upon this Intelligence Organization Restriction of Right Act 1985. Your Lordship, for a moment, kindly see this act. Provisions of this act, Your Lordship, may kindly see. They are saying I have violated this provisions of this act, my lord. Therefore, this is to be restricted, my lord. Your Lordship, may kindly see here. Section 3, my lord. Respecting right to form association, freedom of speech, etc. No member of the intelligence organization shall be a member of or be associated in any way with any trade union, labor union, political association, or with any class of trade unions, labor unions, or political associations. Be a member of or be associated in any way with or raise fund for or hold office in or functioning in any manner, in other manner for any other society, institution, association, or organization that is not recognized by the central government as part of the intelligence organization of each one of the member is or is not a purely social, recreational, or religious nature, or communicate with the press or publish or cause to be published by any book, letter, pamphlet, poster, or other document, except with the prior permission of the head of the intelligence organization, or except for purpose of official duty, contact, communicate with any person on any matter relating to functioning, structure, personal, organizational affairs of the intelligence organization, of which he is a member. Use the name of the intelligence organization of which he is a member for purpose of authorized by the head of the intelligence organization, or in any other manner except for the purpose of relating to the official work or functioning of the organization itself. Explanation: if any question arises as to whether any society, institution, association, or organization is a purely social, recreational, or religious nature under clause B of this subsection, the decision of the central government thereon be final. No member of an intelligence organization shall participate in or address any meeting or take part any demonstration organization by anybody of persons for any political purpose or for such other purpose as may be prescribed.
What do you say? What is your submission?
My humble submission, they are taking the stand that in view of the provisions of that intelligence restriction rights act
But the constitutional provision under Article 301 2C supersedes the statutory provision. Just see the constitutional provision. Let us see the constitution. Article 311 2C. Read it.
Where the president or the governor as
read from the top.
Article 302 I am pressing that. No such person.
Read the top. Dismissal, removal, and reduction of rank.
Or reduction of person employed in civil capacities under the union or state. No person who is a member of the civil service of the union or an all India service or civil service of the state or holds an civil post under the union or a state shall be dismissed or removed by an authority dismissed or removed by an subordinate to that by which he was appointed. 2. No such person as mentioned as aforesaid shall be dismissed or removed or reduced in rank except after an inquiry in which he has been informed of the charge against him and given a reasonable opportunity of being heard in respect of those charges. Provided that where it is proposed after such inquiry to impose upon him any such penalty may be imposed on the basis of the evidence adduced during such inquiry, and it shall necessary to give such person any opportunity of making representation on the penalty proposed. Provided further that this clause shall not apply where person is dismissed or removed, reduced rank on the ground of conduct which has led to his conviction on a criminal charge, where the authority empowered to dismiss or remove a person or to reduce him rank is satisfied that for some reason to be recorded by the authority in writing, it is not reasonably practicable to hold such inquiry, or where the president or the governor, as the case may be, is satisfied that in the interest of security of the state, it is not expedient to hold such inquiry.
Yes. This clause is invoked in your case. Because the regular procedure which is contemplated under is given a go by because of the constitutional provision. That is the logic.
Yes.
You have taken the ground regarding non-compliance of this provision and in your original application they filed before this one. And they have also filed their counter affidavit.
Yes.
Where is that counter affidavit? Why they have stated that why they have dispensed with this provision? Where is that? Where is your counter affidavit? Have you not filed the original application?
Sorry, Milord, this is a transport brief. And
we have filed.
Once you have taken the responsibility,
this is not honesty.
have you got a copy with you? You must file all the pleadings, otherwise how?
Yes.
Repeatedly, we are telling you that when you are challenging the order of the Central Administrative Tribunal, please file the original application, file the counter affidavit, rejoinder, etc., so that we can have a clear picture before us.
Yes.
That what are the stand taken by the different parties before the tribunal. Because the scope of interference here is very limited. in view of the several decisions of this court as well as the Supreme Court. So,
One technical point is also there, my lord.
no, you say that please file the, if it is not there, please file it.
I'll file this, my lord. But one
No,
submission.
you file will,
My lord, I will file along with the affidavit.
like on.
This order.
Don't argue and, like on, the land and council for the. And counsel for the petitioner seeks some time to file the original application, counter affidavit and all the before the, which was there before the land and central administrative tribunal in OA number 260/207 of 2018, है ना? Court of this matter, के file करियो कौन?
One week time.
6 for 1 week time, matter be registered in commencing from 4th August 2020. 4th August. The S.Mishra is present for the central government council. Or senior panel. Yes, Mr. Ojha for the petitioner and Mr. Swan. Yes.
Lordship, my permission. Let my lawyer friend will take in, come with the preparation that this is the order of the law and tribunal is hit by that 105 of the CAT procedure rule. The court has already held in so many decisions. Yes, that after 21 days this order was passed. Therefore, this cannot.
You have already been removed from the service, right? So we are trying that whether it is a fit case at least for issuance of notice or not.
Okay.
So you satisfy us, then we'll see them.
Okay.
Yeah.
Okay.
Item 2.
May I please, my lord? It is that case your lordship had heard last week regarding this Airport Authority of India, your lordship. My lords, just to recapitulate, the case is that two organizations were there. One was International Airport Authority and the other one was National Airport Authority. Both were merged by an act of the Parliament in 94. My lords desired to know which act. That's what I was not carrying the act, so I had come with the act. So with my lord's permission, may I please place the preamble of the
You are
act?
challenging the order of the land and single judge. That order is Annexure 7. What was your prayer before the this court in that writ petition? Come to the first paragraph of the single judge order.
No. May I please?
Yes.
The petitioner through this writ petition seeks a directive of this court for the integration of housekeeping section in the integrated airport division into the terminal management operations department, aligning it with organizational structure of the housekeeping staff and the airport division. Furthermore, the petitioner requests that the seniority of housekeeping staff in the AID be maintained and recognized within the seniority framework of the operations terminal management department. This is how it has been quoted. My lord, may I draw my lord's attention to as it has been read in the original writ petition.
Where is that?
Yes,
What is the writ petition?
my lord, it is annexed 1 of my lord. The entire writ petition. My lord. It is therefore, it is therefore humbly prayed that the Honorable Court may graciously be pleased to admit the writ petition, call for the records, and issue a writ in the nature of mandamus or any other appropriate writ oblique writs, oblique orders, directing the opposite parties to stop discriminating a particular set of employees without any reasonable classification as per law, and further be pleased to direct that housekeeping section of IAD, that is International Airport Division, should be merged with Terminal Management Department in line with NAD housekeeping staff, and the seniority of IAD housekeeping be sustained seniority of operations terminal management. Thus, justice may be to the aggrieved executives and non-executives of housekeeping section of the erstwhile International Airport Division. This is what was the prayer. That
What does it mean?
my lord,
What does it mean?
Place me, lord.
There
Otherwise,
is a housekeeping section in IAD, means International
Airport Division.
Airport Division. There is a
Housekeeping-
housekeeping
No,
section
national,
in
no.
National
Airport Division.
Airport Division.
No.
So you want
Both are
its
merged.
merger.
They were merged.
Okay.
The case,
They
my
they
lord.
were already merged.
My lord, may present the case in
Yeah.
2 minutes. Your
Yeah.
Two different organizations were there. One was the International Airport Division, one was National Airport Division.
Hmm.
In both these divisions, there was this cadre called housekeeping. In the International Airport Division, from which I come and my likes come, there the educational qualification was BA and with diploma degree.
No, just let us be clear. When this merger took place and
Nine-
what is the that clauses were there?
1994 by
Where is that? Where is
Airports Authority of India Act.
Airport authority.
Yeah. That must have taken care of the
Yes.
employees from the two
Yes. Yes.
organizations,
Yes.
right?
Yes.
When the two streams
Yes, ma'am.
merge,
Yes.
Merge.
what will be their seniority?
Right.
How they will
That is all-
be treated? Everything
Ah.
might have been,
Yes.
and
Because-
in accordance with that act,
Right,
things will
it
be
is,
decided.
my case is, everything was done. The merger was done. Seniority list was prepared.
Hmm.
I was in the higher rank. They gave promotion to those who came from the National Airport Division.
Hmm.
When I complained that how could you give promotion to him while he was not even eligible to be promoted ahead of me, then they issued an order that merger is cancelled. The HR department of Airport Authority of India is issuing an order that the merger is cancelled.
Despite there is a parliamentary
No
law.
parliamentary merger. That is the case.
So
Which provision?
which provision you say?
My lord, the preamble itself. The Airports Authority of India Act, page number 1.
Read it out.
My lord. An act to provide for the constitution of the Airports Authority of India and for the transfer and vesting of the undertakings of the International Airports Authority of India and the National Airports Authority to and in the Airports Authority of India so constituted for the better administration and cohesive management of airports and civil enclaves whereat air transport services are operated or and are intended to be and of all aeronautical communication stations for the purpose of establishing or assisting in the establishment of airports and for matters connected therewith or identical thereto. This is the preamble, Your Lordship.
Okay.
My Lord, may kindly have a look at the salient features of the bill. The last, E. Every officer or other employee of the International Airports Authority of India and the National Airports Authority serving in its employment immediately before the appointment to become an officer or other employee, as the case may be, of Airports Authority of India with option to resign. My lord, this makes very clear that two streams are being merged and everything will be part of Airports Authority of India. My lord, this pursuant to this act, the act of merger was started. And Your Lordship, there were cadres, common cadres in both the organization, there were uncommon cadres. This housekeeping was a
No,
common.
how this seniority thing was dealt with, whether it was there that those who are serving in international, they will be placed higher on in that way, whether what is there?
Mine, I'll come to that.
Because your case is based on that, who is junior to you
Mine.
has been given the promotion
Right.
while you are depriving of.
Mine.
So in spite of the
My lord,
merger,
let me kindly come to page number 137. This is the common seniority list, running page 137.
37.
Mine. This is the common seniority list that was prepared by Justice Krishnamurthy Committee appointed by the Parliament. They have done the exercise. in 2013 on the basis of the rankings at 2005, because 2005 is the new recruitment rule came into force. So all those cadres that existed before 2005 were stopped at that point, and new cadres and other things under this Airport Authority of India were framed, and that is there as Annex 1.
So it is basically from the date of joining of in that particular post that has been taken into. Suppose you
Length of service is
length of
only.
service is
Not really, because
How come?
the airport, the housekeeping cadre to which I belong and the others belong, they were different in these two different organizations. That is where it begins.
No, हाउसकीपिंग रो जो यादरे इंटरनेशनल अच्छी एवं नेशनल ये जितला अपन मर्ज करचंदी basis must be who has joined first.
No.
So he is to be placed first, or there was any other
Not
fact?
only that, that's what I'm placing. In International Airport Authority Division, from where I come, the qualification of joining
You have a superior qualification.
and joined at the upper division.
Yes.
And we had 4 promotional bases. The same housekeeping cadre in domestic division had only matriculation as the qualification, and there were no promotional avenues for them.
Okay.
Only when this merger came, there was a requirement that they need to be brought up to our level, and kind of based on their experience and our qualification, it was a big exercise and carried out by none other than a Supreme Court in order to do that. On that basis, this list was prepared. So taking everything into our qualification, their experience, everything into account, this list was prepared. Common seniority list.
Okay.
This is called common seniority list, and
Now the promotion is given violating the list.
My lord, I stand at number 6, and they have given promotion to 12 and 13.
Number 6.
My lord,
What is it? Viswas.
Timir Vishwas.
Your number is
6.
6. Viswas. What is it? Timir.
Timir, Timir.
Timir Viswas. You can give me promotion now.
12 and 13.
DJ Mukherjee and Chatterjee.
My lord,
A.
this
Chatterjee.
is in eastern region, and this has happened all over the region. That's why there were many petitioners.
no. We are confined. Please confined to your place.
My lord,
You have grievance against number 12 and 13.
my lord.
12, 13 metric and HS.
Have you made them party?
My lord,
Are they
the case began on challenging this, as your lordship should.
No. Ultimately, if they are likely to be affected by
No, they are not to be affected, my lord.
how you say so?
We are to be given promotion along with them. That's what is our case, your lordship. We are not
No, but you want you are placed above them in that common
seniority.
Now, once they are given promotion, if they go above you.
That is the point. My lord,
Now, once you say that without hearing them, the same thing is to be maintained now.
My lord.
Then they comes below you.
My lord,
So they are affected. So they are likely to be.
If there are limited posts,
my lord.
you say that to stick to this seniority list.
Right.
Then they will be affected. You have to be promoted. You have to be first.
My lord, the history of the case is, once this promotion is given,
Now we are examining necessary parties.
I'm just explaining. Now, when I objected to this, what happened is a bigger cause of action. That they said that this merger is cancelled.
So as that.
That is what is. I will show my lord. That is page number 143, your lordship.
143.
My lord. So this affects everybody. So there was a.
Just a minute.
The second last paragraph. The merged seniority list of housing terminal management is cancelled.
Hold it. Yeah.
Second last paragraph.
You would have
Marker.
marker would have clear one.
My lord, merged seniority list of housekeeping and
The
terminal
senior
management
list of housekeeping and the terminal management as on 1/2/2005.
circulated earlier, maybe please treated as cancelled.
Earlier, may please be treated cancelled.
And they go on publishing separate criticism list after that. So this affected everybody. So that's why it was a mass writ petition filed challenging such discrimination. That is the reason. And comparative was given.
What do you say?
This
Whether it
these two
is
people.
stands cancel.
My lord, that the common senior list has been
The
stamped.
exercise has been
But
done
they have-
pursuant to the act and Honorable Supreme
Yes.
Court has done it. And
Yes.
in one stroke of one word, you cancel everything.
No, my lord, everything has not been cancelled.
Then what has been cancelled?
The senior list prepared was cancelled, but that order has not.
The exercise has been done by a Honorable Supreme Court
Who
judge.
has prepared the seniority list and on what basis? Act
Yes.
came, the Honorable Supreme Court judge was entrusted to do the exercise. It's prepared it in 2005 and just one line
One line.
cancelled is gone.
And bring lot of litigation across the country. Because of this what? Lot of litigation in this country.
What is
So
the reason?
That order at that time has not been challenged, my lord. This order.
You invite, this kind of orders are being passed, as a result of which the courts are flooded with litigation.
Moreover, my lord, he cannot claim for a merger or demerger, my lord.
You know,
Legal-
forget about that case. You just tell whether this merger stands or not.
Merger.
Then why have you written this? Who has given you authority? Parliament has made a law merging both the organization. You, in a stroke of word, you say that everything goes.
Where is that? How the learning tribunal has dealt with it?
No, tribunal. Honorable single.
Sorry, learning single judge, sorry.
Honorable single judge, my lord, may kindly turn to page number 225. 225. 224 is the page from where he starts discussing the issues. To my misfortune, Honorable single judge has gone with their contention, the merger. However, the fact is that from Annexure 3 to Annexure 9.
So as that finding,
Mine.
no merger.
My lord. Paragraph 7 at 225, Your Lordship.
Yes.
The
Okay.
counsel for the opposite party contends that
Never.
IAD and NAD were never part of the same cadre. It is argued that reliance on a document addressing rectification of anomalies and the adoption of a unified scale and designation of non-executives of AI is insufficient. The document doesn't substantiate the merger of cadres or provide any indication thereof. I will have to agree with the contention of the counsel of the opposite party. Now, my lord, my humble submission, Annexure 3 to 9 chronicle the way the exercise was carried out. That anomalies were fast fixed. As I said, that there were no promotional.
Common seniority list was published and
It
everything.
was prepared. So that has not been adequately perused. The second, paragraph number 8, the petitioner has placed reliance on a common seniority list
That's
purportedly implemented through a circular dated 1812. While it is undisputed that such a seniority list was prepared, there is no evidence in the form of supporting to indicate that it included the merger of housekeeping cadres. My lord, the housekeeping cadres have been merged by an act of parliament, and 3 to 9 are it gives a history that how it was merged. The court observed that in the absence of explicit provisions establishing common cadre rules for the housekeeping staff of the two erstwhile organizations post-merger, it would be improper to draw inferences or assumptions treating the two cadres as unified. My lord, here my humble submission is, in 2005, as I said, the new recruitment rules came. There the housekeeping cadre was totally abolished. It was made part of terminal. Housekeeping cadre doesn't have any rules because the cadre ceases to be operative from 2005. In the new cadre rules, terminal management comes, and there is documents adduced again from 3 to 9, showing that this cadre is being abolished and it has been part of terminal management. Everything is clear. My lord, I would draw my lord's attention to this common seniority list, the previous page to that common seniority list that I was showing. Page number.
Was not challenged what has been stated.
My lord.
This particular document which you showed, that is 143 regarding cancelling so and so.
My lord.
So the learned single just said that was never under challenge.
Well, we had prayed for non-discrimination of it. That challenge was specifically not that the effect of that Order is that they discriminated us and said that you were never part of the common airport authority of India. No merger. That was the point on which the case was filed. That you cannot discriminate us. Everything has been done. We don't object. You pulled them up level by merger. We don't have any objection. Then you are now giving them promotion and throwing us by the side for no good reasons. Your Lordship, I was just drawing my Lord's attention to the creation of this merger of this housekeeping cadre with terminal management. My Lord, 126. It's very clear. Very clear, my Lord. 126. My Lord. Consequent, may I please? Consequent to...
Just a minute.
My Lord. Consequent to creation of terminal management discipline in terms of headquarters letter dated 18 November 2003, the cadres of erstwhile APTC and housekeeping stand merged to terminal management discipline. So here, the housekeeping cadre ceases to becomes part of terminal management, and the ranks of terminal management are given below. Therefore, in the recruitment rules, there is an absence of housekeeping cadre because the housekeeping cadre has been merged to terminal. So that is what has been inappropriately appreciated, that since there is no common cadre rule for housekeeping, so it cannot be said that it is an...
There is no more housekeeping now.
No housekeeping now. It's part of management. That is clear that it has been made part of management.
Terminal management discipline.
May I submit one thing, madam?
Yeah.
In the prayer, the petitioner has prayed for further be pleased to direct that housekeeping of IAD should be merged with the terminal management operation department, madam.
Already merged.
Yes, madam. In one hand, he has already accepted that common merit list has already been wiped out. So that has not been challenged. In other hand, he is praying for merger of two cadres. So, the petitioner can pray for merger of two cadres. In one hand, he is admitting that two cadres have been merged. In other hand, he is praying for the direction to from this honorable court to merge for two cadres.
Because that was cancelled, so now...
That has not been challenged. That means they have accepted the merit list, my lord.
It means that particular merger which has already been taken place by, we have pointed out that has been cancelled. So the prayer is that...
Thereafter two senior merit lists have been prepared. That has been accepted by the petitioner.
Yes, that's what we are saying, that on that basis, we are saying...
The merger is the...
Housekeeping is observed by the terminal this thing. Terminal, what is that? Terminal management discipline.
My subsequent that has been the senior list prepared, that has been cancelled, my lord. And two separate lists have been prepared.
Now, what they have done after that, they have cancelled it.
Once they have accepted.
No, nothing else. It's a...
You are trying to evolve your argument on the basis of his submission, or you have really read it?
No, my lord. They are in one hand, they are accepting the merit list.
File count notice, file issue notice. The appellant, Timir Viswas, as
Para 19 of the judgment is the finding.
Judgment and order dated 8/11/2024. Passed by the land single judge in WPC number 730 of 2018. It is further prayer for a direction to the respondents not to discriminate the appellant and his likes were from the erstwhile housekeeping cadre of IAAI, your full form content.
International Airport Authority of India.
International Airport Authority of
Erstwhile.
In short, IAAI, and extend promotion and promotional benefits the basis of common seniority list under Annexure 8. to the said writ petition. The learned counsel for the petitioner submitted that in the writ petition filed by the appellant and others, appellant and total कितने file कर दिए and 34 others कर दिए 34 others before this court. The prayer was made for a direction to the opposite parties to stop discriminating a particular set of employees without any reasonable classification as per law, and for a direction that housekeeping section of International Airport Division bracket hereafter sought IAD should be merged with terminal management of the operation division in the line of National Airport Division bracket installed NAD housekeeping staff, and the seniority of IAD bracket like the housekeeping to be sustained, the sustained seniority of operation oblique TM means terminal management department, so that justice can be done to the aggrieved executives and non-executives of the housekeeping section of S2 IAD. During course of argument, the learned counsel for the petitioner placed the preamble of the Airport Authority of India Act 1994, which reads as follows: quote that an act to Prathamarvashi up to thereto. He also placed the salient feature of the bill in clause E, Bhotaji section. The Land Council submits that after the enactment of 1994 Act, the bracket is 1994 Act. Hello. About 137 per the number, 137 per
Common seniority.
Common seniority, yes.
An exercise was undertaken by the Honorable Supreme Court Judge, and a final common senior list of
Terminal management.
Yes. Final common
Seniority list of senior superintendent, oblique superintendent, bracket housekeeping.
As on 8
1/2/2005.
under
Eastern region. Eastern region.
Eastern region was prepared, wherein the appellant's portion was shown as number 6. Okay. The
12 and 13.
Paragraph is submitted that in that seniority list, one Mr. D.J. Mukherjee and A. Chatterjee were placed in serial number 12 and 13, right?
Respectively.
And those persons have now been given promotion. Those 2 persons have now been given promotion above the petitioner.
139.
Page 139 before us.
Annexed 10.
by order dated 24/10/2014. The order passed by the Executive Director, bracket HR, dated OC 24/10/2014. So the name,
6 and 7.
6 and 7. T.L. Mukherjee and sponsor. Stop. The Land Council submits, you refer to page number 143, right? Submits. The seniority list that was prepared was cancelled by order dated 6/7/2016, issued by manager, bracket HR, wherein it is stated as follows. Quote kar diyantu. So your last sentence ta achi, merged in inverted comma bhitar merged seniority list of housekeeping and terminal management as on 1/2/2005 circulated earlier may please be treated as cancelled. The then come to page number 126. The Land Council for the petitioner urged that not only after the enactment and preparation of the common seniority list, an order was passed by the Joint General Manager. Come to that page number.
Joint General Manager.
Joint General Manager, bracket personal. Dated 17/5/2008. 7/5/2008. Wherein it is clearly mentioned that consequent to the creation of terminal management discipline in terms of
Central Headquarters. Central
Headquarters later dated 18th November 2003, the cadres of erstwhile APTC and housekeeping stand merged to terminal management discipline. That is page number 126. The council submits that when the matter was challenged before the land single judge, the land single judge has what are the findings on this particular aspect? You are showing paragraph number 7.
He has not just taken into account these documents. You can just say that there is
Para 7 finding.
The land single judge
19
has
also.
not taken into account the relevant documents and has been pleased to hold in paragraph number 7, 8 and 10 put 10 as follows. Quote कर दियंतु 7, 8 और 10 है ना. It is the contention of the Land Council for the petitioner that the interim order on the basis of the metal documents available on record and the governments taken in the writ petition which has not been taken into account properly, not sustainable in the eye of law. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. The Land Counsel for the Union of India, Mr. B.S. Rayaguru, you are the central government senior panel counsel. Accept notice on behalf of all the opposite respondents. Extra copies of the writ petition be served on the
airport to separate.
airport. Notice. So, then you tell me for whom you are accepting the notice.
Union of India.
Only Union of India accepts notice on behalf of opposite respondent number 1. So far as respondents number 2, 3, and 4 are concerned, is there any panel counsel for Airport Authority of India?
Actually, as per circular, we have to represent. But
they have their own panel, Mr.
Correct. The
There I am also.
requisites.
Since sir is there, he can notice.
You are appearing in the writ petition.
she may accept.
Then
Intimate the authority.
so we'll who are accept appearing.
She notice. Is better.
Tell us the names of the Land Counsel who are appearing for.
She was appearing in the writ petition.
The writ petition she was appearing.
Se kouchanti khali lekha heichi represented by advocate Ms. Sitari.
That is wrongly written.
So letter better no requisites you filed.
Notice the issue.
Issue notice so and so requisites be filed for issuance of notice by speed post within a week. Matter be listed after 4 weeks. So far as this is the writ petition which has been filed, there were we said that there were a number of petitioners. So have you filed similar writ petition so far as the other petitioners?
So they are working in other division. Jurisdiction.
They're confined to writ petition number 1 only, since he was under the jurisdiction to
That's being deleted. Under direction.
Rajasthan got a line like it, there's one. So those 35 petitioners filed the writ petition numbers one so, but the writ petition, the prayer in the writ petition was confined only to the appellant, Timir Vishwas, right?
Obliged.
You have an application for two applications.
Higher भी issue notice कर दूँगा.
Item 3.
Then item 3, my lord, I filed my additional affidavit. Where I have asked the departmental rules division, that is under NHRA. I'm serving the copy of hard copy. Affidavit.
Your Lordship, I'm for the caveat to Your Lordship. We've received the online copy, Your Lordship. The matter may come tomorrow. It can be heard.
Filed on behalf of the petitioners.
Ma'am.
That
Yes,
copy has been served today.
My lord, soft copy I have served, but I'm serving the hard copy.
Okay, hard copy you are serving on the Land Council for the opposite party.
Opposite party.
Okay, madam, what do you want?
That the matter may be taken up tomorrow or day after tomorrow, Your Lordship.
Tomorrow there is
It's-
a different law. All right, it will come next week. Like the Land Council for the Union of India has filed an additional affidavit, which is at flag C, and hard copy of the said additional affidavit has been sought today in court to the Land Council for the opposite parties to seek some time to go through the same and request the matter to be listed next week. Put up this matter in the week commencing from 28th of July 2025.
Published.
Your Lordship.
Mr. Deepak Guchayat ko naam likhi dewe, Central Government Counsel, and Ms. Sailabala Jena, Land Counsel, appearing for the opposite party. Yes.
Item 4.
My lord, for looking to withdraw the case.
File a memo.
My lord.
Mr. Behra, Land and Counsel, appearing for the petitioner, 6th permission to withdraw the writ petition, and Mr. Dilip Kumar Mahapatra, Land Counsel, appearing for the State Bank of India, Rairan, Rajganpur branch, Chandragarh, is present. The memo is taken on record. The writ petition is disposed of as withdrawn. Yes.
Item 5.
My lord, on behalf of Sukandalai, the petitioner is on being with his proposal. There is something going on between the manager and petitioner. Let it come next week.
By the order 9/7/2025, Lord Sir directed to submit the proposal, but till yet he has not submitted.
Today is in bank. Today's petition is bank discussion going on with the manager and petitioner. Let it come next week.
Have you given the proposal?
He is in
That
bank.
is the instruction that no proposal has been submitted.
Today he is with his proposal in bank.
This order was passed on 9/7.
Why this matter will be kept
And
pending?
filing, why? You're filing this kind of petition and you're buying time.
Because they might not be proceeding for this reason, that a writ petition is pending and some orders may be passed, all these things. So if you are submitting the proposal, they will consider it already there.
You will record the function.
Because otherwise, this is not maintainable. What has been challenged here?
Here, my lord. In fact, my lord, you want, my lord, the regularize the loan accounts also, my lord?
Or any kind of steps taken under SAFISI Act?
No.
Then it's simple thing. Go and approach the.
Today, even if you succeed, we can't give a direction for OTS. We can only request, we can say that let the bank consider it. We will pass that order. and
No, the
place.
prayer of the opposite party bank shall not be directed to settle the loan account against the person under the OTS. The prayer.
There is a OTS scheme. And he will apply. He said that it has already been filed today. So if any such proposal is given, you consider, and we are not expressing any opinion,
Yes.
right? Look on the writ petition. By order dated 9/7/2025, when a submission was made on both opposite parties bank that the petitioner has not submitted any proposal for settlement of the loan account. The Land and Counsel for the petitioner took time to instruct the petitioner to do the needful in that respect. Today, when we made a query to the Land and Counsel for the opposite parties bank as to whether any proposal has been by the petitioner for settlement of the loan account, the answer was in negative. The Land and Counsel for the petitioner, however, submits that the petitioner is approaching the bank today with such proposal. Stop. In this writ petition, prayer has been made by the petitioner for a direction to the opposite party number bank to settle the outstanding loan against the petitioner under the OTS scheme or refacement or for payment of the same in suitable installment. If petitioner has already approached the bank today as submitted by counsel for the petitioner, it is expected that the bank shall consider the proposal in accordance with the prevailing guidelines. Accordingly, we are not expressing any opinion on the said issue. Accordingly, the writ petition is disposed of. Yes.
Item 6.
Your Lordship, I am in virtual, Your Lordship. Your Lordship, I am in virtual.
Please argue your case.
Your Lordship, no, Your Lordship, I am in virtual mode. Today I am not capable to submit the matter due to my missing my file. May be taken up next week.
You are appearing in which matter?
Item number 6, Your Lordship, supplementary.
Six after lunch?
No, Your Lordship, no, Your Lordship, today not capable to submit matter because my brief office brief file missing out.
Are you arguing a criminal matter before us now? There are two lists actually. One is, this is a writ petition we are now taking out.
Writ petition, Your Lordship, writ petition.
Okay, this item number 6 is WPC 16513 of 2025.
Yes, no, yes.
You are not even aware about your.
No, aware that file is not available. Your Lordship, number, just I am expressing the number. What is the exact number?
The next item, that one. Yes.
Your Lordship, the matter may be taken up next week.
No, are you sure that this item number 6 is your matter? WPC number 16513 of 2025, the petitioner Shakuntala Jena.
Shakuntala Jena, Your Lordship. Your Lordship.
You are Mr. Sudhanshu Jena. Yes.
Yes, Your Lordship. SS Jena.
Sudhanshu Jena, appearing through virtual mode, 6 for adjournment. Place this matter. Yes, urgent procedure.
Item 7.
Your Lordship, I'm on behalf of Mr. S. Das. A new VNAMA was filed on 7/7/25, but PAR was not reflected in this cross list. The ex-counsel informed us just.
You are appearing for whom, particular?
I'm on behalf of S. Das, for the petitioner, Sangram Keshari Das.
S. Das?
Yes, Advocate S. Das.
There is no S. Das in the.
No, yes, Your Lordship, I have filed a new VNAMA. We have filed a new VNAMA.
The names of the London Councillor Saroj Kumar Mishra and his associates. Have you taken consent from the London Council?
Yes, Your Lordship.
Where is your VNAMA? File it.
We have filed it. On 7/7/25, we have filed it. But it's not reflected in the call list.
7/7/25.
Yes, Your Lordship.
Whose name that Wakalatnama is there?
Saurabh Das.
Saurabh Das.
Yes, Your Lordship.
Saurabh Das and associates.
Yes, Your Lordship.
The mention is made on behalf. What is your name? Please give it. Your power is there in that.
No, Your Lordship.
A mention is made on behalf of Swanso, on behalf of Mr. Saurabh Das, that Press Wakalatnama has been filed on behalf of the petitioner after taking consent from the previously engaged counsel, and the said Wakalatnama be placed on record. Place this matter on such and such date. The Wakalatnama, if any, filed by Mr. Saurabh Das and associates from record, and their names shall be reflected in the clause list. Yes.
I have instruction to appear. Let him start to copy so that
UCO Bank. Give the name of that. To also submits that he has instruction to appear for the UCO Bank Sahid Nagar branch Bhubaneswar. Let a copy of the writ petition be served on the London Council, and so you are to file your VNAMA, and if any VNAMA is by the London Council, the same shall also be placed on record, and the name of the Lion Council be reflected in the cause list. Yes.
Item 8.
My lord, today I am a copy of the affidavit by the petitioner. I am for the opposite.
That, your lord, may I please your lordship?
Yes. Your client has received that letter issued by the bank dated 9/7/25.
No, my lord, I supplied him that copy. My respected senior served me. He had been to Visakhapatnam for his health checkup, my lord.
But see the affidavit, the
My lord, rest amount.
February 31st August or September. Bank has to consider what we can do.
You consider it, we were not expressing any opinion. We have given that figure that 55 লক্ষ কোন দেবে সে 31 অগস্ট 25 তারিখ বাকি দেবে by 30th of September 25. You have received that affidavit copy. Take instruction from the affidavit. We are discussing of it.
You consider it. In any case, you have to consider. We can't do anything.
As for the order dated 21/7/2025, the petitioner Manoj Kumar Sahu মানে কি এটা petitioners তো হচ্ছে সমান সো লেখা আছে আচ্ছা ডাইরেক্টর হচ্ছে ম্যানেজিং ডাইরেক্টর Mr. Manoj Kumar Sahu, who is the managing director of Senator Infotech Private Limited, has filed an affidavit wherein in paragraph number 3 and 4 it is stated as follows. Quote further in and shall. Copy of the affidavit as well from the London Council for the ICICI Bank. ଆପଣ ଗୋଟେ କଣ କହୁଥିଲେ ଇଏ କରୁଛନ୍ତି ବୋଲି କିଛି ଫାଇଲ କରୁଛନ୍ତି କି ଆପଣ
ମୁଁ ତାକୁ ଏଇଟାର ଯୋଉ affidavit ଥିଲା
sorry, you consider the London Council for the British State Bank submits that the bank will consider the affidavit filed by the petitioner and pass necessary order. Since it is the bank wish to the suggestion given by the petitioner by way of the affidavit, we are disposing of the writ petition without expressing any opinion on the merits of the case. Direction to the bank to consider the same and take a decision and communicate the same to the petitioner within stipulated time, but within 1 month পর্যন্ত আপনি জানেন within 1 month. Yes.
Till that, no coercive action.
Why? You are ready and willing, you are not paying anything.
Next here, in fact, my lord, the date that 31st June was on his own.
Consider meaning that just intimate your decision within 1 month. That's all. Yes, next.
Item 9.
Mr. Barik.
May. This is a case where I am the guarantor for a company and repeated valuations were taken under Annexure 4, 5, 6, 7, where the valuation has been as 2 crores above all the time.
We are not on that. You are challenging a auction sale notice of the year 2019.
And that is pending, your lordships.
Where
Before
it
the
is
DRT.
pending? Huh?
Now it is pending.
Where it is pending?
DRT.
Huh?
DRT.
Huh? So why are you again challenging before us? Once you are already, you have already challenged before the DRT.
Same
so
is,
why are you challenging before us?
Same is pending. And
pending ମାନେ ଆଉଥରେ ଆମ ପାଇଁ challenge କରିବେ ନା କଣ? ଯୋଉ ଜିନିଷ ଗୁଡାକ already the matter is sub judice before another forum.
My respectful submission will be that they have already sold it in
maybe
70.
Now the DRT is in session over the matter, and these prayers which you have made before us is under the consideration of the DRT. So, are the question of
my only prayer will be before your lordship is that I will be approaching the bank with a much
make that prayer also before the DRT.
Because they have already sold.
Tell us the number. We just don't know.
SA number 123.
SA number
123
of
2019.
You move application.
This writ petition has been filed by the petitioner Muhammad Nihal with following prayers, 40 prayer. It is stated at the bar that SA number 123 of 2019 is released before the London DRT, and self-same prayer has also been made before the DRT. Therefore, since the DRT is in session over the matter, we are not inclined to pass any order in this petition. It is accordingly disposed of. Yes.
My Lord, may say that the offer I will be giving
give that offer before there.
We have given liberty. You move application.
That one line can be.
It is up to the petitioner to approach by filing appropriate application before the DRT in interim application to seek necessary relief. Yes, next.
Obliged.
Item 10.
Item 10, your lordships, I find that there is a noting, but all the LRs have already appeared. I think Mr. Bose had appeared.
Lordship, I am appearing for Mr. Episodes.
All of them had
The
appeared.
LRs are on record.
Lordship, the one is the father of the deceased OP1. So
Not
this
father,
implement may be dispensed with.
Mother.
One year na who she the na kon
Bansidhar Sahu.
Just a minute.
Bansidhar
Sahu is now dead.
He is the father of the deceased OP1.
कौन प्रश्न को से कहउछंती जे Bansidhar Sahu they are already on record. Is
Yes,
it? Are you accepting this statement?
Yes, Lord.
So then matter ends there. Let me know. The admission notice which was issued to PLR number 1E, Bansidhar Sahu has returned answered with postal endorsement, inverted comma vitare, addressee deceased, inverted comma ends. This is Rothal and senior advocate appearing for the petitioners submit that PLRs of the PLR number 1E are already on record, which is not disputed by the London Council for the opposite party. Stop. So now the notice is to be held sufficient. Now, have you filed any counter affidavit?
Your lordships, everything is ready for hearing. If your lordships just can put it on.
Let's see that. Pleadings are complete. You meant to say?
Pleadings are complete. Actually, lordships, this is a matter which has come from the tribunal. So we have challenged the order. So it's a statutory proceeding.
No, it's all right. You have, Mrs. Roth, we are insisting that that original application and the counter affidavit.
I have filed everything. But after we had filed.
Or then we can keep it, tell us a date, both of you, so that we can keep it for final disposal. Any short date,
Any week, your lordships, after 15th August. I'm a little preoccupied.
Okay.
After 15th August.
Let it be on 18th then.
18th.
This matter in the week commencing from 18th of August 2025. There is one consensus of both the parties. Place this matter under so and so for final disposal. Yes.
Item 11.
My lord, we have filed the IA for modification of order. So I pray the order dated 18/6/2025 may kindly be corrected and reflected as 18/7/2025.
IA number so and so. This is an application for rectification of the date of order. Land Council submit that inadvertently the order has been shown to be passed on 18/6/2025. In fact, the order was passed on 18/7/2025. The Land Council appearing for the opposite parties and no objection to such prayer. Accordingly, the order dated 18/6/2025 be corrected as 18/7/2025, and the it will be uploaded in the High Court of Orissa. Yes,
urgent certified
IA is disposed of, urgent certified copy of.
Item 12.
The order for 18/7/93 our entire order. है ना? Yeah. अब बाकी जो copy था
Your Lordship, although I'm ready and prepared for today, but I'm in consultation with an advocate who will be joining me next week. So kindly give a date. Maybe the Wednesday.
Mr. Author, she's asking for time. So, are you available next week or?
Next week, your lordships, a little difficulty. I think that big matter also
Tell us
comes
a
up.
date. Tell us a date he's here so that on consensus we can.
Because anyways now he's represented by a lawyer, so he will not be troubled so much. Any date after 15th.
I have to come. So kindly.
No, you will be by the side of your lawyer to assist him. There is no problem. But we are fixing a date, and Madam says that he has some problem. So let it be after 15th August. So we are fixing it on 18th then or 20th.
20th, because the previous matter 18th. So
Just a request. If next week is not possible.
She has some difficulty. She has already expressed in just previous matter. They stated, right? So
you also need time because you will engage the
you
lawyer.
will be engage the lawyer and also advise him all these facts. So Dr. Uttam Kumar Samanta, the petitioner, appears in person, submits that is contemplating to engage a counsel to argue the matter on his behalf, and another date may be fixed. Stop. Ms. Pami Rothland, appearing for the respondent, is present. On consensus of the parties, list this matter on 20th of August 2025. That is a Wednesday, so.
Made permit 18th.
18th we have already.
If she's available.
No, she's available, but she has already fixed another final disposal matter. So it will take some time. That is how.
Okay.
Yeah. Yes.
Oblations.
Item 13.
Senior counsel on his leg. So I
pass over.
One person.
Okay. Yes, next item.
Item 14.
End of the list.
କହିଲେ ତ ପାସ୍ ଓଭର କଣ
End of the list.
ନାଇଁ ଆସିଲେ ଆପଣ ଅନ୍ୟ କୋଉଠି ଅଛି
ଯିବି ଯାଇକି
I'll come back. Please, sir.
Item number 14 and
No, 14 also pass out. Mr. Tiwari is on this call, sir. One second.
Item 15.
Just to absolutely Lordship, one of the main issues was last time, your Lordship kindly recollect that the existence of a status quo order, the sale was effected under the surface area. So your Lordship had directed me to examine the CMP record where the status quo order was passed, and I have examined it. Just as far as that suit is concerned, your Lordship may see on 10/7/2016, the bank issued the sale proclamation. The plaintiff of that suit, where status quo order was passed, who is not a party here, Samarendra, he filed the suit saying against the petitioner number 2, who was the mortgagor. Garrett, alleging that this property he has entered into an agreement to sell with me, so for specific performance contract, making the bank as a party and saying not to effect the sale till his right is decided. Now, the suit was filed on 15/7/2016. On 10/7, the sale was filed on 15/7. Then 6/2016, the civil court passed the status quo.
We are looking at your date chart. So 6/12/2016.
My lord. Civil court passed the status quo.
Whether by that time the bank has already entered appearance?
No. This status quo order is not relevant. I'm sorry. This status quo is not. This is just 2 or 3 dates. I'm preceding it. Thereafter, I'll give you lots of the dates.
Yeah.
But this is the initial. Status quo order was vacated in FAO on 23/2017. Now, that was challenged in CMP. So we now come to the CMP where the relevant order was passed. Let's see the CMP.
Mr. Mishra, you are for the bank? Who is appearing for?
I'm appearing to the bank.
Just before I place this, your Lordship may kindly keep it in mind that the suit was filed by a third party and status quo order was passed. That was vacated in FAO. And thereafter, this same plaintiff came before this honorable court challenging the vacation of order. And on 12/5/2017, status quo order was passed. Copy to be served on Mr. P. Balaj. Right, sir? 12/5/2017, first day. Status quo order was passed. 19/5, the sale was conducted. Now, 12/6, sale certificate was issued.
What is the CMP number just?
CMP number is, CMP number to be.
586.
586/2017.
When it was filed, date of filing.
21/3/2017.
21/3/2017. This is the very first order when the status quo order was passed, or after the service of copies, etc., and was issuance of notice.
First day.
First
Very
day,
fast.
when it was listed for admission.
Okay, so
12/5.
first date this order was passed. And when the matter was restated, when the matter was taken up on that date, 12/5/2017, so till that date, at least you have not served the copy on the bank counsel.
No,
who used to appear.
It was its order of that date.
No, I'm telling that.
No.
So obviously 12/5/2017, the London Counsel for the bank was not present. That is how the order was passed, status quo order was passed, and order was passed also that to serve a copy on Mr. Balkrishna, who used to appear for the bank, right? Yeah.
Lord, then 1905 the sale was conducted.
And did you serve the copy on Mr. Balkrishnan?
Yes, that is what
On what date?
I'm just showing. 12/6. Now 17/6 is the relevant date. Annexure J/3, your Lordship, at page 200. This is the communication given by the counsel for the bank. Lordship says that.
Yeah.
Page 201. With reference to the subject noted above, this is to inform you that the
Where is that?
page 201.
Yes.
Annexure J/3.
Please.
What you got?
This is a letter by the advocate to the bank. Okay.
Right, sir. With reference to the subject noted above, this is to inform you that the said appeal arises out of an order judgment passed by the London Additional District Judge for passing of such order being aggrieved, the present appeal has been filed. As it's seen, the Honorable Court has directed the counsel for the appellant to serve copy of the said appeal on the undersigned. The same was served to me. Thereafter, I sought a copy of the order of the Honorable Court, which was served also thereafter. On such submit, the same was intimated to our third branch, who in turn informed that the said matter is now under the lookout of SARB Cuttack. Hence, this information to you. Please note that the said post is posted for filing.
No, what is this number? Is something wrong? But this is, you said that a CM filed, and in the CMP this order was passed, but it is mentioned in the past.
Yes, it was initially nomenclatured as SEO, it was subsequently corrected as CL.
So page 147, L/3. The conversion is there.
Okay.
It was converted to.
Okay, so there is no dispute that SAO was filed. SAO was filed before this court.
Before this.
What does it mean by SAO?
Second appeal against order.
Okay.
That means against FAO order. Against FAO.
That was done to that CMP.
CMP.
Okay.
Now, this, yes, your Lordship is asking me a question, when what is served? There is no information because I appeared on 9/10/2017.
No, what we want from you, Mr. Mohanty, that the question that the bank was having the knowledge of the status quo order passed by this court on 12/5/2017, when the state, that is very relevant in this case because what you are advancing. So question is that when that copy was served and whether that copy was served with the status quo order or not.
Except this letter, there is no other material on record.
Then how can we?
This letter, he says,
goes to the crux of the matter.
He says that yes, I have received the letter.
No, again, suppose he receives it after 1905.
No, that he doesn't say.
No, that is how can we presume at this unless because
in any case it was on received.
Yes.
Prior to that, sale certificate was already issued.
Yes.
See, କହୁଛନ୍ତି 19/5 ଯଦି ଆମେ ବାହାରରେ ପିଇଲା then how sale was conducted in view of the status.
But it does not know.
But that is the crux of the matter. Unless the council, bank council is aware that such a status quo.
That order also says that serve a copy on.
Yes. But the council says the same was served on me thereafter, and I sought for a copy of the order, which was served also thereafter. There is no.
Then the only presumption is in 6/2017, it was served on him.
At least you should have taken mention before the court that
I appeared.
take the notice by way of special messenger to serve this order on the bank.
He was
Lordship,
not a
can-
party to that.
I was not the
No, the council, whosoever it
Yes,
may be.
I was, no, not council, means the present petitioner number 2 appeared on 9/10/2017, after the passing of the order,
Right. So,
9/10.
9/10,
so this CMP was filed by the
by the plaintiff.
plaintiff. The question of knowledge of the bank, because that goes to the root of the matter.
Yes.
You are again and again harping that an order was passed in CMP, and in spite of that, the sale was conducted.
My only submission is, from this letter of the council, it doesn't appear that he has received it late or after the sale was conducted or whatever it is.
Like that. We have to give a specific fine to that effect. Once we adjudicate that they have flouted, the bank has flouted the court's order of status quo, and
Now,
sale was conducted.
for that reason, I'll show one other thing. Kindly see Annexure 16 at page 106. Page 106. If that is there, my lord, on 29/6/2017, they have received the communication, the council, because 17/6 the communication was received. Now 29/6, they are giving me a proposal under OTS. But kindly visualize, they have put forth that this is our due. Put the property to auction. 24 lakhs was due. They realized 29 lakhs. It is already completed.
Yeah, just a minute. This was written to you.
Pardon me? Yes.
Annexure 16.
16 at page 106.
General manager.
At this juncture, they are not disclosing that status quo order has been passed or it has already been sold, money has been realized, nothing. But they want that I should go for OTS, and bona fidely believing that I deposited the money. Because I had
If the sale was already done, there was no question of OTS.
that should have seen. Totally misleading. Because after you have sold it for alleged dues of 20 and sold it for 29 lakhs, that means you have realized your dues. Then what was the again occasion to give me a chance for OTS? You give us, we'll settle your account. And I immediately complied
If
with
the
it.
sale would have been in a lesser price,
Yes.
the OTS I can understand.
Yes, I can understand. But that,
If it is a higher price, because 24 lakhs was the due, 20 lakhs, it was 29 lakhs it was sold. So there was no occasion for them to ask for.
They disclose that status quo order is passed. We did not know. Whatever explanation they give, nothing is written. It is plain and simple that you deposit this. And next page, 107, I deposited. But they, your lordship says, because by this date, the CMP was dismissed. So when the CMP was dismissed, they realized that there is no further question of going for OTS, and they refused it without any reason. Lordship says. So, Lord, I am telling about this conduct. Not only that, your Lordship says, your Lordships had asked me a very pertinent question. What was I doing? I means petitioner number 2. Two doing. Well, in view. Lord, as soon as this CMP was dismissed and the sale deed was executed, within 45 days of the provision, I preferred essay because I could not have gone to any other forum. Except going to DRT, I could not have, for meeting my grievance, challenging the sale, I could not have. I went on 30/12/2017.
Petition number 2 was the guarantor.
Guarantor.
Then the DRT, this issue was raised also.
Yes.
The order passing of the sale order in spite of the
Yes,
status.
it has taken note of that, and that's why it allowed the claim in my favor. Allowed the case in my favor.
Ajay, where is that order of the DRT?
So, Annexure 2, at page 40.
Come to the operative part of the.
Just page 40 here. Yes. That is, it starts from paragraph 6 at page 57.
57. Yeah.
Then the contentions, the Lordship must skip over. Page 62. It is noticed by this tribunal. The property was sold and sale certificate was issued. Amount was adjusted as per show cause filed by the respondent bank. The amount is ready, already adjusted. Statement of account which is filed by the respondent bank clearly shows the applicant is paying the amounts regularly, and there are several credit entries of the account. Also, amount of rupees 1 lakh is paid by the applicant, and respondent number 1 issued notice under 13.2 to the borrower, and account was declared NPA on 31/5/2015, which is filed by the applicant for essay, but notice to the company is mentioned 31/5/2015, and hence the notices are issued in defective in nature. He has referred to only one notice, but there are 4 notices where 4 dates of NPA are mentioned. That the tribunal further observed the valuation of the property as per valuation report as an engineer, and the valuation of the property is 83 lakhs somehow, and the distress value of the property is 72 lakhs somehow, and the property sold to respondent in favor of Bijay Kumar Das for an amount of 29 lakhs and so. The tribunal found that the property is sold at the lesser price and conducted the auction which is less than the market value of property. This tribunal further noticed that there are 4 number of 13.2 notices, and in every notice the date of NPA are different in respondent bank. This tribunal further noticed that while the interim orders of Honorable High Court is pending, the respondent bank has stepped to conduct the auction violating the status quo order of the Honorable High Court, sold the property and sale certificate was issued. The acts of respondent bank is not, they have not followed the procedure as per law. While the matter is pending before the tribunal, and the tribunal directed not to register the property in favor of third party and not to change the revenue records without leave of the tribunal, and the photographs which are filed by the applicant show that the respondent is taking steps to dismantling the walls and cutting the trees, which is not permission and violation of this order. Tribunal. With the aforesaid observation, SA is allowed so and so, and the directions have been given, which have been complied with.
Now you have got your money. Respondent number 1 means who? Respondent number means bank.
Right.
Bank is directed to return the amount.
Yes.
With interest.
Yes. From the date of deposit within 1 month.
So
this order has been set aside in appeal.
where is the appeal order?
Annexure 1.
Annexure 1.
Annexure 1.
What are the relevant paragraphs of that?
Status quo order?
No. About the DRT order. Appellate tribunal's order.
Regarding the status quo order?
No. Why he set aside the order of the
paragraph 17, it deals with page 37.
37.
Page 37. Paragraph 15. So far as valuation is concerned. No, sir. 1 second. It starts from page 36. paragraph 13.
1-3. Yes.
This is not the case of the respondent that demand notice or possession notice or sale notice were not served to him, or they were not properly affixed or published in accordance with provisions of law. Thus, the respondent was required to file the objection under 13(3)(a), the Surface Act, if he was having any grievance with regard to contents of the demand notice, but no such objection was raised despite service of demand notice. Further, the symbolic position was taken on 4/7/16, but the same was not challenged within 45 days. Thus, the respondent had waived his right to challenge the same. As such, obviously, reliefs granted by the tribunal below were demand notice, possession notice, and sale notice were time barred. No application for condonation delay was filed for the delay was below. Rather, this issue was not preferred over dispute over, despite the objection taken by the bank in its counter objection. Thus, all the reliefs granted in this regard were time barred. In para 4 of the essay pertaining to limitation, it was stated that the cause of action arose on 2012-17 after taking physical possession of the premises, but that cannot be a ground to challenge the earlier steps. For the purpose only the possession and order of district magistrate could have been challenged, for that no ground was taken or any relief was sought. Thus, the tribunal below has passed an order without considering the limitation aspect. This is so far as limitations. Then, the case has argued, turning to the merits of the case, guarantor has not pleaded category that demand notice, possession notice, or sale notice were not served. Since no objection, he repeats that. You see, with regard to date of declaration of account, and it cannot be raised. He repeats that. Even otherwise, the appellant has stated that the respondent has deposited some amount even after the demand notice dated 6/2/15. Therefore, after classifying the account as NPA on 28/12/15, fresh demand notice was issued on 24/2/16. Thus, mentioning of different dates of NPA for no reason given. Then 3, valuation of the property. So far the valuation of the property is concerned, the bank has obtained valuation report from the approved valuer, which was not contradicted by the respondent at a relevant time. If the property was being sold at a lower price, the respondent Ashok Kumar Das, guarantor, was free to produce another buyer. Apart from this, owner of the property sold the same property to one Samaradana for a meager amount of ₹3 lakh. So it cannot be said the property was sold at lesser price. The valuation report submitted by the respondent was obtained after 1.5 years from the date of sale, so it cannot into 2 applicants. This is the reason given, whereas the tribunal had given the reason 83 lakhs. Then paragraph 17, status quo order. With regard to status quo order, Honorable Court of the Bank was also arrayed as a party. There is nothing on record to show that this order was conveyed to the bank before auction of the property and issuance of sale certificate on 12/6/17. On the contrary, the letter dated 17/6/2000, Exhibit J, is on record demonstrating that the bank was informed about the pendency of the civil appeal before Honorable High Court, which was written by the advocate to the AGM of the bank. So bank was not aware of the order of the Honorable High Court on FA and the sales. Thus the principle of so does. These are broadly the 3 issues which have been answered against.
What is the principle laid down in that Surjit Singh and the other 2 decisions? That those are of the Honorable Supreme Court decisions. That has been referred in that paragraph number 17. The principle laid down in this one so are not applicable. What is the principle laid down in that?
I'll give those decisions. I'll give those decisions. But question is that
We have seen that. Surjit Singh, what is the reference?
This thing.
It is not mentioned prior to that. The citation is not there.
No.
So,
No. Our paragraph
previously been 9. Only reference are you having those decisions? Mr. Mishra, this is the data decision citation. Paragraph 17 ne joda lekha hai. Supreme Court ko data decision lekha hai. Which is not applicable. So what was the principle laid down there?
That we had showed to show that
interim order was passed.
So therefore,
during the pendency of the interim order.
Just the citation tati ke dega.
देखिए दे दिए ये देना है
दियो तुझे लिखी दे Surjit Singh. So you interim order upper boda, interim
Okay.
order.
Surjit Singh and
96, take it to 96 will be good, no?
No. We know.
AIR 1996 Supreme Court.
96
135.
Supreme Court. So the Supreme Court has said that
Surjit Singh.
if a person has been
AIR
restrained,
AIR. Para 9, just see.
if a person has been restrained not to do certain act, his right to do so has been restrained.
Para 9.
Jehel Kanti Nagano.
Jehel AIR 2013 Supreme Court.
Sorry.
2235.
I'm extremely sorry.
Okay. So that is all your submission.
Yes. But that question is, your lordship had asked what I had done. I had appeared after the sale, after the order was passed, and I had appeared. And immediately when I came to know, I approached the tribunal. Tribunal says, not only that, there are four notices with 4 different NPA dates.
No, when notice was issued, 13-4 notice.
Your lordship sees, I'm just giving your lordship the dates. In the date chart, earlier date chart.
13-4 notice is the last date in the account. Bank.
3 chapter date खाली place कर दो.
Last तक पड़ा है.
Last तक. Last हो चाहिए.
So obviously it must be prior to the date when it is.
Page 4.
Page number
4 of that earlier date chart.
कितने date तक पहुंचो?
So it is 4/7.
4/7.
2016.
Okay. 4/7/2000.
Charita 1, 2, 3, 4. All the 4 are different.
No, ठीक है जी. We are not on that. 4/7/2016 notice. That is the last notice. So obviously
that was not challenged.
That was not challenged.
No, that was not.
So that could have been challenged by you. There was a scope before the Learned DRT. खाली मैं जानिए चाहूँ
I
could have gone. So then thereafter this order was passed.
Civil court passed the order.
Civil court passed the order on 6/12/2016.
So therefore we stayed there, and that was ultimately vacated by the culmination of the decision by this honorable court in CM. So therefore, after that I went to DRT.
No, 4/7 notice for a they finalized it. They might have proceeded also, but some kind of order was passed in that 6/12/2016, but ultimately that sale was finalized on 12/6/2000. Sale certificate was issued.
Yes.
What happened on 20th December 2017?
20th December.
You say that you derived the cause of action on that day. What happened? Without challenging the sale notice, without challenging the
Section 14.
Nothing was challenged.
Appellate court has observed that.
That's
legal position was so and so, and तापाई 14 जो surface आया कला safety ताप बोरे.
What happened on 20th of December?
20th of
You say
December.
that cause of action arose on that day. After taking position for the premise.
20th of December.
Position is taken.
Position was taken and that was delivered to the auction party.
Physical position was taken.
That day you say that your cause of action.
Action arose, and within 45 days I went to.
Limitation is the problem.
That is only confined to section 14.
Para 13, how will you get over?
Power 13, your lordship.
Para 13.
Paragraph 13 of
impugn order.
The appellate court order. Yes, bro. Sale notice, that's what I'm saying. The sale notices being filed, or rather on specific, were not challenged because immediately the suit was filed and the parties were diverted towards the suit and status quo. Immediately the civil court granted status quo. After the culmination of the civil proceeding and after possession was taken, I went to day. Asking a question to myself, what I could have challenged? I could have challenged that your notice is defective because of wrong NPA. That's all. But the sale, I could not have challenged. The sale, my grievance is against the sale and taking over possession. That is why I'm done.
You have the plaint with you.
Plaint, I have. I can file it. Sutra plaint, no?
Who is that person who filed that civil suit?
That's what.
Samarendra. He says that he has a subsisting contract with petition number 2. And he filed the suit for specific purpose. Another aspect subject to your lordship's consideration, the suit is going on. Was going on that time. And they have filed written statement. Bank has filed. Different number 2 has filed. 1 has filed. It is going through a checkered litigation till the Honorable High Court. Is it appropriate that yes, they will sell it, and that too after realization, and that too kindly mark the conduct that after selling, you say that 24 lakhs is due and you put the property to sell. Got 29 lakhs. Keep quiet. But still you are asking me, give us OTS, we'll do it. And when the CNP is dismissed, rejected. We have no further right except to approaching the tribunal.
And refunded your money also.
Refunded virtue for lordship's order.
What is you were a party to the suit?
Obviously.
What was your written statement?
Written statement is that I have not just.
Was it a collusive suit or not? That's what I want. Collusive suit, maybe. Looks like.
I cannot see.
Bank has not filed written statement.
Right.
No, not bank.
Bank has filed.
They have filed
There are 2 suits, Millard. 2 suits. 2 brothers.
It appears to be a collusive suit, looks like.
I'm only on the point that whether validity of a status order is
that is
maybe. I need not go into that issue because that is not within my domain. Or bank had appeared and filed it instead.
Bank would have filed only. Bank would have contested it. You must be a party also because it is specific suit. Whether you consider it to the plaint or not, that is a question.
Yes.
Mr. Mishra, we'll hear from you. Please make your submission. Thereafter, we'll hear you. Yes.
Sir, if your lordship, at the outset, I would like to take your lordship to order dated 27/2/2023. This matter was heard, in fact, by Justice B.R. Sadangi and M.S. Sahoo. After hearing, this order was passed, in fact. The last portion, if lordship looks at, but the fact remains, the property in question has already been sold, an amount of 29 lakhs has already been realized by the bank. Therefore, adjusting the loan amount, balance amount should have been refunded to the petitioner. Instead of doing so, the petitioner have called upon to deposit 25 lakhs, which is deposited before the bank. Ultimately, the same was deposited at the bank before the DRT. The next date, on 19/7/2023. The sale proceeds of the property of the petitioner at 29 days, that the bank will refund the balance 4 lakhs. So far the demand raised by the petitioner to 25 lakhs, same will be refunded to him. Initially the court, it has already been done.
Paragraph.
Sir, here actually the operative portion is 110.
Yes. Under 10.3.
The confirmation of sale by the bank under Rule 9(2).
Where are you reading?
110(2).
Acha, all right.
The first one is alternative remedy.
That's one.
The confirmation of sale of the bank under 9(2), Rule 9(2), in which the successful auction with the vested right to obtain the certificate of sale of the immovable property in the form given in Appendix 5 to the rules, in accordance with Rule 9(6). In accordance with the unamended Section 13(8), unamended, the right of the borrower to redeem the secured asset was available till the sale or transfer of such secured asset. In other words, the borrower's right to redemption didn't stand terminated on the date of auction sale of the secured asset itself. The remaining and remain alive till the transfer is completed in favor of the auction procedure by registration of the sale certificate, delivery position, so and so. However, the amended provision of Section 13(8) makes it clear that the right of borrower to redeem the secured asset stands extinguished thereunder on the very day the publication of the notice of the public auction under Rule 9 of 2002 rules. In effect, the right of redemption available to the borrower under the present statutory regime is drastically curtailed, would be available only till the date of publication of the notice on Section 9 of 2002 rules, not till the completion of the sale or transfer of the secured assets in favor of the auction procedure. The bank, next paragraph, bank, after having confirmed the sale under 9(2) of 2002 rule, could not have withheld the sale certificate under Rule 9(6) of the 2002 rules and entered into a private arrangement with the borrower. The High Court on 226 would have applied equitable consideration to override the outcome contemplated by the statutory auction process prescribed in the SRFC Act. The two decisions so and so, and the court in the result appeal succeed and the return set aside. But here the question is, sanctity of the auction has been dealt with in para 91 and 92. It says thus, what is discernible from the above is that it's the duty of the court to jealously protect the sanctity of auction conducted. The courts ought to lose in interfering with auctions, otherwise it would frustrate the very object and purpose behind auction and deter public confidence and participation in the same. Any other interpretation of the amended section 13(8) would lead to a situation where multiple redemption offers would be encouraged by mischievous borrower. The members of the public would be dissuaded and discouraged from its participation in the auction process, and the overall sanctity of the auction process would be frustrated, thereby defeating the very purpose of the SURFACE Act. Thus, it is the larger public interest to maintain the sanctity auction process of the SURFACE Act. Here, sir, everything has been completed. And it has not been challenged. Sale notice, auction, nothing has been challenged. But their only contention, interim order was there. So interim order never communicated. Two brothers filed two different suits from two different persons saying that agreement to sell is there. So that will not stand a bar to process the SURFACE Act proceeding. Here the interim order that was passed by the High Court was never communicated to the bank. Counsel was communicated. On which day actually it has not been known to us. When the lawyer issued a notice to us about the interim order, we came to know. By that time, sale has already taken place.
But after auction sale, why have you gave a letter for
So that letter may be irregularity. Let me confess, my lord. I saw that actually like in 16. It must be irregularity. But prior to that, it has already been done. Everything has been completed. That doesn't create a subsequent right.
And he deposited the money.
The amount.
Sir,
and you now refunding 25 lakhs.
He deposited for OTS. Let me be candid, my lord. He deposited the money for OTS.
In one hand, you sold it. And the other hand, you enter into an OTS, took that money.
So that
and sell
consideration
29 lakhs, that also you have taken.
Let me candidly confess, that's wrong. It's a bad notice. Or your worship knows in bank, somebody has got hold of somebody to issue that notice when the sale takes place in a different branch altogether. The bank, they give it to a different entity to give a sale process to be undertaken. Main bank may not be aware of it, or somebody deliberately had done it. But that doesn't defeat the sale which has already taken place. And sale is not in violation of the court order.
No, sale that was conducted, it's all right, 19/5/2017. And okay, sale certificate means he must have deposited. Okay.
Sale certificate thereafter, my lord. Sir, auction sale on 19/5/2017. 19/5/2017.
12/6/2017. Actually, that should not have been made because by that time sales certificate.
I've indicated in my counter also. This is date to
You've given the interest.
Sir.
For unjust enrichment interest. Have you paid?
No.
Sir, there's no question of they are not paid or it's not a case they are paid. There is no interest in this matter. Sir?
Further claim that is pending.
And interestingly, paragraph 7, if your worship looks at in that interim application 16.
I would say by age or 25 lakhs people offer for 4 lakhs.
That they have refunded.
But I have only interest here. That is interesting. That's from the date of 17 to 17 to 26.
But my esteemed brother is saying that you received that amount on 30/7/2017. because you issued, give a OTS proposal and.
That 1,40,000 or something like that.
No, 25 lakhs. They have
25 lakhs.
No, 25 lakhs was even much later.
When?
Or 25 lakhs.
After the DRT order.
After the DRT order.
After the DRT.
Not here.
Okay.
Here actually the OTS proposal, they must give an initial deposit. So that deposit was.
Then that 4 lakhs extra which you have realized from the sale consideration, 1 lakh the OTS proposal, and subsequently after DRT order 25 lakhs. Everything you have taken.
No, that was so that 1,40,000.
That is what we are thinking. That is a part of unjust enrichment on your part.
Sir, that is absolutely correct. He should not have issued that letter. But that doesn't defeat the process that has already been undertaken to sell. Let me be very candid, my lord. I couldn't have explained much what I heard back to somebody for lordship. That sale doesn't get affected. Once the sale has taken place, sale is not. And much prior to that, the sale notice was given, auction notice was given, and the auction was held, and the valuation report was also published. Valuation has been given. Everything has been complied with. That has not been challenged. That has not been challenged. So the 25 lakhs cannot be said to be unjust enrichment with due respect, my lord. But that was after the DRT passes the order. That has already been refunded because we challenged that order. That was also without.
If not 25 lakhs, at least that 4 lakhs and 1 lakh something after OTS.
But 4 lakhs was not received. 4 lakhs was the excess of the sale
amount.
proceed.
That is refund only on 19/7/2020.
So with interest.
You paid with interest.
With interest.
No, interest.
They were refunded with interest.
Interest in. Interest in.
Sir, 25 lakhs was returned on 27/7 after the High Court directed, my lord.
Without interest.
Right.
And we wait for 4 lakhs amounts.
If your lordship looked at para 7 of the interim application, here the question of with due respect, my lord, that unjust enrichment may not arise here. If your lordship looks at para 7, page 7 of IA 16130.
80.
No, 130. That is an IA filed, my lord, on 18/9/2023.
Which for that auction purchaser?
Yes, and
What?
Page 7, let's say, similar. As stated, the opposite bank has already refunded 25 lakhs to the petitioner as regards refund of 4 lakhs after adjustment of the sole proceed against the loan outstanding. It is most humbly and respectfully submitted here that, as per the calculation sheet filed on Annexure B to the petition, the bank is entitled to recover an amount of 4,59,000. As such, this honorable court is graciously passed an order in refund of 4 lakhs to the petitioner and pass such other order as honorable deemed just and proper. Still outstanding amount is there outstanding against them.
What is the nature of property that was sold? Bonds it as
The date of mortgage, it was a piece of soil.
Building. Homestead land. It is
No.
construction.
The date of mortgage, it was soil. Subsequently, it converted to homestead.
Oh, that's it.
After the mortgage.
Soil application was given on
Soil is not
So,
island. Soil is
one can only convert by section 8.
high agriculture.
so what about your client? Your client is still interested.
yes, sir.
There was a building also over that.
Building.
Your client is now in possession of that.
And also that position is given by banks during the after process of the sale certificate.
Yeah.
But then after the overall says created some set of there and police says that locks that building nowadays and given a notice that not to enter that place.
Where is that property now?
At
That was a cashew processing unit was running there.
No.
Not over that land.
That was
It
mortgage
is
for
all
the
mortgage.
loan which has been availed by the cashew process.
What date the copy was solved and
So I told, because I could not find anything on record except that letter under the annexation.
And
Except that
Balkrishna
letter.
himself conducted the case. Balkrishna himself conducted the case.
So therefore, Your Lordship has, when the copy was served is not there on record. But counsel has not stated that he has received late or anything, whatever, etc. Whatever explanation. He has just said that I have received.
communicated. Agreements that were filed on that 17 already.
Hot order.
Yes.
On that day, there is nothing, let us see that status quo.
Yes,
The CMP is there.
same period.
CMP is there. Yes.
Sir, page 27 of the rejoinder.
Order number 2. Order number 3.
Order number 3.
But if this order, Mr. Mahathi does not indicate that even on that, when the order was passed, Mr. Balkrishna was present in.
No, he was not.
He was not present.
He was not present.
Who usually appears on behalf of State Bank in course of the day. In course of the day. And he is not saying that he has not received on course of the day or little late or anything, whatever explanation he is not giving in an exchange.
So they should file the receipt showing in course of the day we have served. They have not stated.
Voter direction that
No, but
has been timely.
it was so that he has been served.
No, the memo.
Yes, it is filed.
No, that's what I'm
Sir,
saying.
he is not the petitioner.
Well, no, I am not.
He is not the same. Yes.
Now that was Alman that name, the pollution, whatever it may be, but there is nothing amounts that this particular order, as per the particular order, is the copy of the CM petition.
Received by Balkrishna.
What Your Lordship, but I would put it subject to Your Lordship's consideration. There is no material to show that it was not served, because he is not saying that. He could. No, he is saying that I have been served. I have been served. He is saying I have been served.
Serving is not dispute. Question is
When?
Serving the order.
Before or after?
So prior to 1905.
Right.
When is the pertinent question? My humble submission is that he is not coming up with that it was not, as per the order, it was not served in the course of the day.
Because you are harping on a particular point, but you are telling that negative thing when the
There is, except this, there is nothing on record.
The pleading also you have not seen.
No, that because there is.
Obviously, you are not the party.
I cannot put it on that.
So we are closing it.
Yes.
Let's go.
I have also given a date chart indicating each subsequent consequent date But I can file a better one.
Petition I have given the date chart.
If you want to file anything, file.
Because I can clarify that deposit of 25 lakhs when it was done. It is there on record.
We are doing one thing. We are just keeping it on Friday, and whatever you want to file it, and then we will close it for.
And if necessary,
And the court dictation can be given so that you can.
hear it for 10 minutes, and
Okay, so.
I'll give it date chart and explain it.
Place this matter for further hearing on
28
20 today is
30th and
आज ये वाला 23 तो so you can keep it if you say on 28th or 30th Mr. Mahanti can be rocky आपको
30th
of July 2025 for further hearing. अच्छा इधर लिखती हो यार the land council, Judicial land council, senior rights some citation taken on the court. ये जो relevant dates टा किए दिला शायद land council for the petitioner file.
আমি ওটা দেইছো কিন্তু ওটা রিডিফাই করে দেই
Can't make a mention your document.
Music.
Parents make a mention your document. Let's say item 30 in today's listing. We have filed a IFR in the ground of petitioner's sister's marriage. It may be taken up today.
Which one?
30, item 30.
That is in the list or?
Yes, your lords.
So how are you mentioning? Yes.
But let's say the mother of the appellant died on 18th of July.
Have you given a copy to the state?
Yes, my lord. Today I have already given.
Interim application copy?
Yes, my lord.
And with the death report?
Yes. Death issued by the council.
Day after tomorrow.
Madam.
ଆଉ ଗୋଟେ ନହେଲେ ଦେଇ
ଆଉ ଗୋଟେ କପି ଦିଅନ୍ତୁ
ଆଜ୍ଞା ଆଜ୍ଞା
କପିଟି ଦିଅନ୍ତୁ ଡେଥ୍ ର ସାର୍ଟିଫିକେଟ ତାଙ୍କୁ ଦିଅନ୍ତୁ so that you will verify
ଆଜ୍ଞା
otherwise it will be again adjourned on Friday.
Let's just now another copy. 27th death 10th ceremony ଅଛି
କଣ
27 ତାରିଖ ରହୁଛି ତାଙ୍କ 10 ଦିନ
ମୁଁ ତ 22 ତାରିଖରେ ଆଣୁଛୁ ମ୍ୟାଟର ତାକୁ କାଲି ତ ବେଞ୍ଚ ନାହିଁ ନା
ଆଜ୍ଞା ଆଜ୍ଞା ଗ୍ରେଟଫୁଲ
ଓ ସରି ଏଠି ଓ 27th ରେ ଅଛି
ଆଜ୍ଞା
ଓକେ ଓକେ
Central bench only has to report. Central bench only has to.
ନାଇଁ ନାଇଁ ସେ ଅଛି ବିଶାଲ ବେଞ୍ଚଟା
ପଣ୍ଡା ପୁରୀ
So we are bringing this matter by way of a special notice, and if it is possible, we ascertain. Otherwise, we will pass the order that the trial court, whosoever may be, he will verify through the IIC concerned IC. If the information is correct, we'll fix that for this period he will be granted bail. You try to give him a copy.
just now I am
Near some special notice. हाँ 3টা বলুন
grateful
ସେଇଟାକୁ ଦେଖି ଦଉଛି ଜୁଲାଇଟା
ସାତରେ ଦିଟା ଲଗେଇଲେ
Supplementary list, item number 1.
yes madam alert
life conviction.
yes 302
shall be considered after receipt of the. These are the deposition problem.
Right.
Deposition problem. Yes.
Item 2.
Conviction under section 376 AB and section 6 POCSO. The sentence to order going to arrive for life and
We are admitting it, but serve an extra copy so that notice will be sent to this. Extra. Yes, next.
Item 3.
Deposition copy to be also submitted. Later admit further. This first one is 302.
302
Okay. Admit for them. Counsel को serially very engaged कर दें. And Mr. Jafrullah, this also matter. It has not been admitted.
No, my case has been admitted and LCR
Admitted.
LCR
What about the next one? CRLA. Mr. Pradhan, your case has been admitted.
No. In my case, it has not been admitted.
Just let us going to admit. No. Baaki see you. Out also
92.
हाँ এটা উপর দিও তো সব সেই কেস লো রাইজ করছ না
ওটা clearly
এসিআর লে 92 বেটা
টা ট্যাগ
এসিআর 92 হ্যাঁ
CRL 723/25 required by the same appellant.
why 2 appeal jail criminal appeal and normal?
জেল থ্রু পড়ে আছে এটা যে CRL হই যাইছি অবভিয়াস রেগুলার ফাইল করছলা
তো এটা
ট্যাগ হইଯିବ দিটা
এটা নাই ট্যাগ নো উই আর ডিসপোজিং অফ সিন্স এতে যে সিআরএল জনে তো
আগে
তাহলে আর কিছু অসুবিধা নেই প্রিজনার্স পিটিশন তো হ্যাঁ জনে লেখা আছে দেখুন যে সিআরএল নাম্বার 92 of 2025. This JCRL has been filed challenging the judgment and order dated 19/3/2025 passed by the London Additional Session Judge Bhadrak in ST case number 85 of 2019 in convicting the appellant section 302 by 34 of the Indian Penal Code and sentencing him to undergo imprisonment for life and to pay fine of rupees 10,000 in default to undergo RI for a further period of 2 months. Stop. It appears that the appellant has already filed a regular appeal by CRLA number 723 of 2025, which has been admitted today. In view of the regular appeal being filed, this JCRLA is disposed of. Yes, next.
Item 4.
The order will be communicated to the appellant.
LCR is also available, my. LCR is already received.
Uthare.
Say appeal tare.
No, it's such out trial court record like जो CRLA number JCRLA ଆଉ ଏଥିରେ CRLA ଲେଖିବ ଖାଲି ଗୋଟେ line ଲେଖିଦେବେ since the trial court record has already been received in CRLA number 538 of 2025 ହେଲା खाली लिखना it appears that trial court record has already been received in some positive year ହେଲା but that's all. Yes, JCRL number 111 of 2025. It's a live conviction, Mr. Pradhan. Item number 4.
4 months.
All right, simply admit.
There is also CRLA 45 by 23.
Same appellant.
My lord. That has been admitted.
Just a moment. Let us see that. CRLA 120 Sullahu alias Padi. अच्छा admit के पीछे 13 एक पेज there eta judgment hଉଛି single appellant ST case 89 of 2017 DJ Kendrapada JCRL टा कसलो judgment कसलो RDJ ST number 89 of 2. Same, let us know. JCRL number so and so. It appears that the appellant Sulabh so and so has already filed criminal appeal. That is CRL number 45 of 2023, challenging the sanction into judgment and order of conviction by passed by so and so and so and so. In convicting so and so. Since the regular appeal has been admitted by order dated 13/1/2023, this JCRLA is disposed of. Communicate the order to the yes.
Item 5.
This filing entering application for bail. Letter, appellant in custody since 2007, man. 2007. It's a, because it's a case about triple murder due to witchcraft.
The bail application was earlier rejected.
My lord.
When? How many times it was rejected? You are filing for bail for all the appellants or
only
only?
So only 2 appellants are there.
No, वर्तमान जो फाइल करते हैं कहाँ पे IN number 1748.
Man.
That is for appellant number 1.
I mentioned.
1 Shatrugna Maji. So his bail application has been rejected earlier.
My lord.
3
Korean now 24.
3 4 14 hours.
He is detaining
3 4
18 वर्ष रहिलाଣି.
just not a fit case. So no 3/4/2014 the first bail application reject ହେଲା ଆପଣଙ୍କର ତାପରେ 14/11/2017, second bail application. again on 29/2024. Twice your bail application has been rejected.
Entire case rest on the evidence of the only
Will
single
not go on merit. What period you have remaining?
18 years.
What is the custody certificate?
Discipline certificate.
Have you got the custody certificate? Hmm. Let me do. IN number 1748 of 2025. This is an application for bail filed by appellant number 1, Shatrugna Majhi. Mr. Jafullah and counsel appearing for the petitioner submits that the petitioner is in judicial custody for about 18 years. The learned counsel for the state seeks some time to produce the custody certificate. Who jail is here? It appears that the bail application of the petitioner was thrice rejected by this court. That is on 3/4/2014, 14/11/2017, and 29/2024. Okay, check correctly. In the interim bail application filed, there is no mention as to whether any such bail application was previously filed by the appellant number 1, and if so, the result of the bail application. The registry shall do the needful to point out in every interim application for bail filed by the appellant or appellants as to whether any such bail application has been earlier filed and disposed of or not, while listing the bail application for consideration. And specific mention should also be specific instruction in that respect shall also be given to the counsel filing such bail application to mention the details of the earlier applications filed, if any, by the appellant oblique appellants, and the result of such application. This order be placed before the Honorable Chief Justice for passing necessary order. All right. This matter on such and such date. The learned counsel for the state shall in the meantime obtain the so and so. And also the instruction about the criminal antecedent, if any, and the conduct of the petitioner inside the jail.
Item 6.
Conviction under section P02 and 34 IPC and sentence figure is life number 134 of 2025 for bail on behalf of appellant number 2.
Your application is now for this IN number 134 of 25. So that you have filed for bail application of appellant number 2. Appellant number 2 not at home.
Janna Bana. Janna alias Jannu Bana.
Yes, you are prisoner's petition ground.
Jannu alias Jannu Banda.
This year, you see, there is only one prisoner's petition. That too of so and so. কারণ তাদের বি লেখা হয়েছি ମୁଁ ଜାକିନା ଜାକି କେସ୍ ନମ୍ବର ତଳ କୋର୍ଟରୁ କିନ୍ତୁ ଶୁଣନ୍ତୁ ନିର୍ଭରଶୀଳ ନୁହଁ। So JCR has been registered. So filed by two persons.
Another prisoner petition.
Oh, see the order dated 5/10/2016. 1 minute, 5/10/2016. Order.
Jana another file.
Appellant 2, according to the proceedings presented was appellant 2 picked up with water and so on so. And bail is granted to appellant 1. Appellant 2 bail is rejected. But where is the appellant? That's not.
That might not have been pointed to the court. You see, this JCRL has been registered only on the basis of prisoner's petition received from this lady. So it is, this JCRL is not for the other appellant.
I have a copy of which appellant.
What is the name of the appellant? Janu.
Janu.
Or the
No, Janu ପାଇଁ ଅଛି ପରା ଏଇଟା ତ ଅଛି ଏଇଟା ଠିକ ଅଛି। appellant number 1 ପାଇଁ ଦେଖନ୍ତୁ ଆପଣ ଯୋଉ କହୁଛନ୍ତି ନା ତାର ନାଁ ହଉଛି ଜଜମେଣ୍ଟ ରେ ହଉଛି କଣ ଡାକା ଆଲିଆସ ଜାକାଲା ବାହାରା। ଆପଣ ତା ପାଇଁ ଆପିୟର କରୁଛନ୍ତି ବର୍ତ୍ତମାନ ବେଲ ଫାଇଲ କରିଛନ୍ତି ବି ତାରି ପାଇଁ। କାହା ପାଇଁ ତ ଆଉ appellant number 2 ବୋଲି କାହାକୁ କହୁଛନ୍ତି ଆପଣ?
Wife of the Jackal Banner, that is Janu Banner. Appellant number 2.
Jackal. नहीं Jackal ଅଛି ନା ଏଠି Jackal ଅଛି। Jackal prisoner petition ଅଛି ନା?
Jackal ଅଛି।
Yeah. ତାପରେ ଇରେ ଆର ବି ଅଛି Jackal and Janu।
ଆଚ୍ଛା ଦି ଜଣଙ୍କର
ଅଛି ନା?
Then it's all right. But ଅଲଗା ଅଲଗା ଡେଟ୍ ରିସିଭ୍ ହେଇଛି ତ ଗୋଟେ କରିଦେଇଛନ୍ତି। Okay. So now your 134 is for
Janu. This bail application is for Janu. It was rejected.
She is in custody since 9/7/2007, Michael.
Rejected 5/10/2016.
Custody since?
Rejected, bail option rejected 5/10/2016.
That's right. Custody since?
Custody, no custody.
9/7/2007.
9/10/2000.
9/7/2007.
9/7.
Is it 9/7/2007?
No. Date of 9/7/2007, date of arrest. From the date of arrest, she was in the
final form. Forwarded to court on 10/7. 10/7/2007. Do you mean to say that here he has not been released on bail? So what about whether he was produced in court? Okay.
We have to call for the report.
No, just ଏଠି ମଧ୍ୟ order sheet ଟା ଯୋଉଟା order sheet ଅଛି ତଳ କୋର୍ଟର ତା ଦେହରେ ଦେଖୁଛି they are in custody. So obviously
one has got the bail.
Produced. Both the accused persons are produced in jail custody. So obviously he has not been released on bail. In the trial court, he was in custody, and after this appeal was filed also, he was never released.
He was granted.
This,
One has been.
appellant number one. So he's right, this, that he's in custody for, except they say, ये period में जाई थी, वो जाई थी, जो corona period, let detach. Now, whatever it may be, you get that custody certificate. The left hand. IN number 134 of 2025. This is an application for bail of appellant number 2, Srimati Jana, alias Janu Mahara, PANARA. The learned counsel for the petitioner submits that the petitioner was taken into judicial custody in connection with this case on 10/7/2007, and she was neither released on bail during trial court or during the pendency of this appeal, and as such, she has remained in custody for more than 18 years. Let the learned counsel for the state produce the custody certificate out of this matter. And କୋଉ ଜେଲ ଅଛି? ବାରିପଦା ନେଇ ଆସନ୍ତୁ ନେକ୍ସଟ ୱିକ୍ ରାଉଣ୍ଡ ଲେଡିଟା ରହିଲାଣି ବହୁତ ନେକ୍ସଟ ୱିକ୍
Item 7.
May plead alongside. And Dr. My past bail application for dismissed for non-prosecution.
Have you surrendered?
Yes, my lord, I surrendered. On 26/7/2016. Thereafter, my lord, on 5/11/2021, my interim bail application was allowed for a period of 2 weeks to attend the Sudhi ceremony of my deceased father. Thereafter, my lord, he surrendered in the right time. And my lord, thereafter, these present appellants were released on interim bail for a period of 3 months by order dated 25/9/2023 by this honorable judge. And he surrendered in the right time. And
who filed this bail application?
My lord, earlier
that is 1 and 3.
Three appellants were.
No, we are not on the latest one. That was order was passed in favor of Munna alias Antarjami Patra and Surendra Naik alias Surendranath Naik. Right?
My lord.
So they were granted interim bail for a period of 3 months.
My lord.
And so the direction was passed that to IIC Bangiri Police Station to have a close watch over the activities of so and so and to submit the report. Okay, you have received the report.
No, my lord. Two appellant, my lord, surrender in time. This is the certified copy.
The report has to come.
Yes,
your conduct during the.
Yes.
So you have filed a fresh bail application.
Yes, my lord. Because
but that was not disposed of. Why have you filed? Left on order number because 1950 of 2023. In that order, we have that application is still pending. That is how it has been. At a list करना थी कहीं. एटा केबे तो dispose of है नहीं खाली लिखा है ना. Okay, लिखो IN number 1712 of 2025. This bail application has been filed. किए file करची?
My lord, two appellants, my lord.
Code लिखी जाती. You have not mentioned.
Petitioners, appellants, my lord.
No, appellant. There are a number of appellants.
3 appellants are there. Out of 3 appellants, 1 has already been died. That against whom allegation.
Why have you not mentioned here the humble petition of the appellants number 1 so and so and appellant number 3 so and so named above most respectfully swear. See जगह लिखी हुआ था.
Sorry, my lord. Transport.
IN number 1712 of 2025. The Land and Counsel for the petitioner submit that this bail application has been filed for appellant number 1, Munna alias Antarjami Patra, and appellant number 3, Surendra Naik alias Surendra Nath Naik, who were granted interim bail for a period of 3 months as per the order dated 25/9/2023, passed in IN number 1950 of 2023, and after availing the interim bail period, the petitioners have surrendered before the London trial court at right time. There was a specific direction while granting interim bail to the London Council for the state to produce the report regarding the criminal antecedent, if any, against both the petitioner and also the conduct of the petitioners during the interim bail period. Stop. Land Council for the state seeks some time to obtain instruction in that respect. Put of this matter in the week commencing from 4th August 2025.
Which appellant has died?
My lord, Bhimo Singh, appellant number 2. Earlier I have mentioned.
No.
daughter
mention is upon back karo. Kebe expert kala?
Date not that instruction.
No, there is no order of
Yes,
evasion.
let us see that. Have you filed the death certificate?
No.
Do you have the
ಇದು ಬಟ್ಟಿ ಲೆಕ್ಕ ಐಜಿ. You come to the order dated 27/9/2019. Citrifala Land Council sponsor does not want to place the application for appellant number 2, stating that he has already died in the meantime. Land Council is directed to produce the death certificate of so and to obtain a report from so regarding the death. There is no order specifically because the appeal would abate so far as appellant number 2 is concerned. If nobody near relatives come up for continuance of that appeal in view of the proviso to section 394 to CRPC. So, have you got that death certificate? Like take down. See this.
Verify.
In the a submission was made on (27/9/2019) by the Land Council for the appellants that the appellant number 2 is dead. Appellant number 2 the Nata Lakidam.
Bhimo Singh.
Bhimo Singh is dead. Say order to pade aso. You order to move back. Stop. This court directed the Land Council for the appellants to produce the death certificate of the appellant number 2, and the registrar was also directed to obtain a report from the superintendent of Circle Jail Baripada regarding the death of appellant number 2. Any such report has been received. Okay. See order to back. neither the Learning Counsel for the appellants have produced the death certificate of the appellant number 2, nor the registry has obtained any report from the Superintendent Circle Jail Baripada stop. Let the Land Counsel for the appellants produce the death certificate of appellant number 2. So also the report we obtained from the Superintendent of Circle Jail Baripada regarding the death of appellant number 3. Land Counsel for the state shall also, in addition to that, the Land Counsel for the state shall also obtain instruction from the inspector in charge of Bangiriposi police station. कौन था नाटा थिला भीमा सिंह अच्छा सेटा होची झारपुखरिया पुलिस स्टेशन ता घरटा होची झारपुखरिया पुलिस स्टेशन regarding the well-being for them, well-being of the appellant number 2. Put up this matter on such and such date. The file be placed before the London Register Judicial who shall नहीं अपन तो superintendent अपन भी नहीं है दरकार नहीं. You free copy of the order be handed over. आपण गोटे चिठी लिखु सांको सुपरिटेंडेंट को ताकर रेकॉर्ड मेंटेन हे दियो सेठी आउ कारण से ये बेले भी बोधे जेल रे थिला कि कोन का सेटा देखिबे ता छडा एई से टू यूनिवर्सिटी दे ना मैटर बी लिस्टेड ऑन वी कमेंसिंग फ्रॉम 4th August 2020. Yes,
custody certificate madam.
Acha custody certificate of these 2 appellants also be obtained along with the criminal antecedent.
Item 8.
May I please, Your Lordship? I am through VC matter. The appellant is in custody since 13/10/2012. On करके. My lord, I am through VC matter. Custody since 13/10/2012, and the appellant faced trial for the offence under section 302 along with 27 of the Arms Act. He was acquitted for the offence under section 27 of the Arms Act and convicted for the offence under section 302. Appellant was on interim bail for a period of 8 weeks in I number 1088 dated 12/5/2023 and I number 1404 of 23. I had order dated 23/6/2025. On the last occasion, the bail application of the appellant was disposed of on the ground that the paper book was ready, and this is a case of 2016. For that reason,
when you were granted interim bail,
I had order dated 12/5/2023.
Okay, take down. Obtain that report about his conduct during interim bail and also period of custody. IN number 1816 of 2025. This is an application for bail. Appellant, Johnny appellant, adire.
Sole appellant, my lord.
Filed by the petitioner. The Learning Counsel for the petitioner submits that the petitioner was granted interim bail for a period of 8 weeks. 8 weeks na 4 weeks?
In I number 1088 of 23, order dated 12/5/2023, 4 weeks. And thereafter, it was extended in I number 1404 of 2023 by order dated 23/6/2025. In total 8 weeks.
The call regular. That is 4 weeks in IN number 1088 of 2023 by order dated 12/5/23 and IN number 1404 of 23 by order dated 23/6/2020. And after availing the same, he has surrendered at right time. The let the learned counsel for the state obtain instruction regarding the conduct of the petitioner while on interim bail, so also produce the custody certificate. Both of this matter will be commencing from 4th August 2025.
Item 9.
Was also directed to the government counsel to take instruction to verify the bail application of the another appellant, that is CRL 683/2017. Yes, be little louder, we are not able to.
Last time you were also directed to verify the bail order number 683 by the CRL number 683/2017, in which one of the appellant has been released on bail by this honorable court.
So, 2 persons were facing trial.
The 4 persons.
4 persons facing trial. So, you were found guilty. And what about the others?
All are convicted and sentenced to arrive for life minor and a fine of ₹10,000 and in default for 1 year minor.
Okay, so far as you are concerned, this appeal. What about the other 3 persons who faced trial?
But they have not been released on bail minor. Only one.
They are released on bail, all the 3.
No, only one appellant has been released on bail, that is Ramesh Pandey.
That is CRLA number 683.
2017. Order dated my lord.
21/2025. What is the name of that person?
Ramesh Pandey.
Ramesh Pandey.
My lord.
He is the appellant number 1 in that criminal appeal.
My lord.
By which order he has been granted bail?
20th January 2001.
That's
25.
20th January 2025. Okay, you are giving the copy of that order to verify regarding claim of parity.
Yes.
What is your summary?
In omnibus allegation, 4 persons are there in the PI card they are identified.
No. Reason
What about the case?
All the same.
And about the period of detention also same.
Same.
Since when you are in custody?
4/9/2013. All 4 persons been arrested.
Trial court record of Assam? Yeah. Anata hochi kono? Tejraj Pandey. Tejraj Pandey was taken into custody on 5/9/2013.
Arrested on 4/9 or 5/9?
Are the learned counsel for the petitioner, learned counsel for the state? The learned counsel for the petitioner submitted that the petitioner is in judicial custody since 5/9/2013. And order जो केस के पास कर दिया लास्ट टाइम एक केस में माने जो 694 है and total 4 persons na
4 persons
and 4 accused persons including the petitioner faced trial in the Court of Learned Sessions Nuapada in ST case number 13 of 2014 and all of them were found guilty under section 302 of the Indian Penal Code and other offences and sentenced to life imprisonment. And one of the accused, namely Ramesh Pandey, along with the 3 set of file coaching 3 jana. 683.
683 Johnny Pandey. Ramesh Pandey. 694 Johnny Tejraj Pandey.
We are not concerned with so आपण कहउचंती वर्तमान appellant जणे जो
694
683 मध्ये जणे फाइल करथिले
683 जणे आउ दे केरले 43 अछि 43 2 जण ओके टोटल
43 accused by mane present bail jaina.
Na, accused.
All right, take down. And the one of the accused, namely Ramesh Pandey, देख सकते थे अपील का बेटा Ramesh Pandey, who preferred CRLA number 683 of 2017, has been directed to be released on bail by order dated 21/2025. Stop. When the matter was taken up on 21/7/2025, Learned Counsel for the petitioner made a submission that the petitioner is similarly situated like Ramesh Pandey, the appellant in CRLA number 683 of 2017, and accordingly he handed over the copy of the bail order to the Learned Counsel for the state for verification regarding claim of parity. Mr. Judicial Naik, additional government advocate, after verifying the bail order and the materials available on record, fairly submitted that the petitioner is similarly situated like the accused appellant Ramesh Pandey was granted by this by bail by this court in CRLA number 683 of 2017. Considering the submission made by the Land Counsel for the respective parties, period of detention of the petitioner in judicial custody, since similarly situated who accused has already been granted bail in the connected appeal, we are inclined to release the petitioner on bail allowed.
Item 10.
My name and mentioned for criminal opinion 43 of 80 of this item number 9. So I am appealing for legal aid only. 43 criminal appeal 43 18 item number 9.
So you are appearing for
Counsel Maji. I note 43
of 2018.
Again.
Business person
Already
just a minute, please wait. 43 of 2018 person. If prisoner's petition has been received from jail to engage Mr. Gyanendra Chandra Swami for appellant number 1 in place of R.N. Mahanti. Tapare wakalatnama filed on behalf of appellant number 1 and 2 advocate Asha. Deepak Kumar Fonda filed advocate for the you are for appellant number 2.
My lord.
Kebekar wakalatnama teta. Appellant number 2
Vice Chair purchase.
Just a minute, let us see. तांको वकालतनामा बाहर करो दो जो मिस्टर दीपक कुमार पंडा जोटा फाइल कर appellant number 2 पाए अच्छा एटा होची 22/4/2025 से प्रिजनर्स पिटिशन केबे का प्रिजनर्स पिटिशन जोटा से appellant number 2 रास्तला at flag E
Vice Chair purchase.
Mr. Counsel authorization is authorization wakalatnama
Vice Chair position.
Prisoner petition 3/2/25.
3/2/25.
No.
There is a flag E.
आपण जो वकालतनामा फाइल कर you are Mr. Deepak Kumar Panda. आपण जदियो फाइल कर 22/4/2025 रे किंतु से वकालतनामा साइन ही जेल रु 29/7/2024 ता परे से प्रिजनर्स पिटिशन दउची आई वांट टू एंगेज मिस्टर ज्ञानेंद्र स्वाई तेणु वर्तमान लेटेस्ट टा होची सेटा देखि से जो प्रिजनर्स पिटिशन टा एट फ्लैग ई
Prisoner petition legal aid
appellant number 2 रो ना होची से जो कोन
Jen Singh
जेन सिंह माझी Just a minute. देखिए कौन पूछेंगे ठीक अच्छे तापर आउ गोटे पिटिशन दे देइछि 2025 रे देखिए तादेरे एटा जोटा फ्लैग ईट होउछंती देखिए केस रो ये सुआंसु तेणु वर्तमान मु गजानंद स्वयं को वकील को मोर केस चलवा एंगेज करियो सत्यानंद स्वयं ना कौन लिखिदेशन गजेंद्र कुमार साहब अच्छा से गजेंद्र कुमार So who has filed this IA number 3073 of 24 for bail? Appellant number 2. You are for appellant number 2, no?
Yes, ma'am.
So there is an interim application. Why are you not moving this?
Not,
IA number बाहर कर लो.
IA
3073.
3073/24 that I has been filed by the Ravi Narayan Mahant.
कौन रवि नारायण?
Advocate.
Advocate फाइल कर दे किंतु advocate तो वर्तमान चेंज हो गया ना but petition रे किसी order पास ही नहीं. So that petition can be moved by the newly counsel. There is no nothing that he has to file one application and move the pending application. Whosoever is engaged, he can move that application. The fact remains that no order has been passed in that application. That is how it has been listed for orders. Appellant number 2 same footing as you. Appellant number 2 रो देखिले के बुट रोइलानी से जो फाइनल
Custody period as the phone.
Same period. Then we are declaring
trial court record देखी दो.
But he says that everybody role of everybody is same. Now he is also entitled to be.
अच्छा इटो लिखी जाऊँ. IA number. IA number 3073 of 2024. There is an application 3073. An application for bail filed by appellant number 2, Chen Singh Maji. Stop. The Mr. Deepak Kumar Panda, appellant counsel appearing for appellant number 2, submits that appellant number 2 is in judicial custody से जो period है ना? He submits that to the accused जो argument दे इतना bail says हाँ ये similar थोड़ी है किंतु जो bail order का handover करला से एक portion तक वो omit कर देगा. But he submit that similar footing. Bail is allowed है ना? बेटा दे दूँगा
दीटा आइतला हमरा 624 गोटे 641 गोटे दीटा
624 टा कौन का ପାଇଁ
से जो टेंसी मा जो दी जन अछन भगवान नायक एंड टेंसी मा दीटा करे हम मु फाइल करथली 624/2025 आई नंबर
624 राव कियर होई गला
दी जन अछन भगवान नायक एंड
टेंसिंग रो तो हे गला आधे बेल हे गला आ आपण को
641 रे तेजराज पांडे
हां तुम 624 रे IA number 624 that is to be confined only for appellant number 1 Bhagwan Naik
and tension दी जन मु लिखछि
ओ बुझी परना दी 624 टा आपण दी जन पई फाइल करथले वर्तमान आपण दी जन करू गोटे जन कर पावर पळै गेला तांको पाकू तणु आपण को पावर केवल रहिला भगवान नायक पई आगे तो भगवान नायक को बेल हेई नी तो
नहीं नीते
हां सेटा लिखि दो 624 2025 this is though this application for bail has been filed for both the appellants. But the Land Counsel for the appellant submit that since separate counsel has already been engaged by the legal aid board for appellant number 2, Chen Singh Maji, and a separate bail application has also been filed. He confines his prayer only to appellant number 1. That is Bhagwan Naik and so on. He further submits that the appellant number 1, Bhagwan Naik, is in jail custody since
Same way.
Bhagwan Naik jail custody. Same period. Same period, बाकी सब समान allowed कर देते हैं ना? Yeah. So bail allowed याद रहेगा A1 released in 624 and 3072 रे 3 रे A2 released है ना? एटर तो ठीक है. Yes.
Item 10.
Last proposal, the state has took time for producing the custody certificate of the applicant.
Last time मैंने 9/7/25 रे.
My lord.
Got it.
एगार वर्ष
Garbo.
तापरे बाकी रहेला state submit qualification and person function. Other 18 instruction जो नहीं थे कौन आसिला?
That flag aim is there.
Flag?
Aim. What is the 2023 report?
हाँ है ना कि ताकू तो चलो जेल अच्छी और कौन होता? Residing in his mother's house. In अच्छा 27/9/2023 ର order ଅନୁଯାୟୀ अच्छा नहीं से Bonalata is residing with his mother's Swanson. Son is Swanson. In-laws family. ये ଯାଇଥିଲା କି interim bail ନା?
No, my lord.
11 ବର୍ଷ ହେଲାଣି 3 ମାସ ଯାଉ their application was rejected on
26/9/23 that apprehended. On the basis that flag aim, the report has to come out.
Flag A.
Flag aim. ତାର 27 ଦିନର ଛୁଆଟାକୁ କୁଅରେ ପକେଇ ମାରିଦେଲା. That's why he has that the wife is staying his
wife is staying now in her father's place.
house, and they are getting that in their religion bail. They might have.
But affidavit टा जोड़ा file करथला amicable settlement ପାଇଁ सेटा को
That is also not
now
filed
he
by-
is disputing that whatever it may be, but he is in custody for that was in 23. So
But actually, the wife is residing in her
Item 12.
May I please? Another 46, another 47. I mean 47.
So as 46 is concerned, I have filed the Vinama, but the previous counsel has filed an I for extension of time of surrender. But he has already been arrested as so far my instructions. So I want to not press that. I will. CRLA
Mr. Bhaddev, CRLA number 46 of 2020 also. IA number so this is an application for interim bail. Mr. Bhaddev, long counsel appearing for the appellant submits that since in the meantime, the appellant has been taken into judicial custody, he does not want to press this application. Accordingly, IA is disposed of. So where is the proof that he has been?
So as per instructions, so subject to
produce the surrender because he was granted interim bail,
yes,
and you are to produce the surrender certificate.
But he has not surrendered in as per instruction. He was taken
was
into
arrested.
custody.
He was arrested.
अरे जहाँ भी हेले वर्तमान तो अछंती
ना
the custody आपण जदि surrender न कर वर्तमान custody अछंती
yes,
बिल
yes, yes.
अच्छा the however the learned counsel for the state submit petitioner submits appellant submits that the petitioner didn't surrender in time as for the date fixed for which non-bailable warrant of arrest was issued by the learned trial court, and thereafter he was taken into custody. In view of such submission, let a report be called for from the learned trial court as to whether the appellant Kusa Majhi has surrendered before the court or not. Put up this matter 4/8/2025 along with CRL number 47 of 2020. This file be placed before the registered judicial who shall send the email to the learned trial court for furnishing the report. Yes.
My lord, in CRL 47/20. Yes. Sir, say connected total 9 जन जो conviction हेले सी जणे ये होची 8 जन. हां एटा नहीं हां ठीक है. My lord. And this out of this 8 my lord.
आगु कोन बिल रिजेक्ट ही नहीं.
सर एथरे 8 ता पळे ये पावर नै रिजेक्ट नै एथरे ये हेची इंटरिम बेल था ना सरेंडर करछंती ड्यू टाइम रे प्रति संकट हो
वर्तमान आपण जो एप्लीकेशन फाइल करछंती there are two bail application. One is for general bail and another is for appellant number 8 only. So now you are pressing for whom?
8 ता मोर पावर नै छंती आ जन फाइल करछंती तो मु जो एप्लीकेशन देछि 83/20 अछि सेतर मु नोट प्रेस करछि फॉर दैट कारण से ऑलरेडी
because you are insisting for 7.
3 for 7 1 to 7.
So IA number 83 of 2020 अपन totally not press करछंती.
No,
only for 8. अच्छा देखो Mr. IA number 83 of 2020 this is an application for bail filed by all the appellants.
All the appellants.
All the 8 appellants. However, Mr. Das, learned counsel, appearing for the appellant submits that since the brief so far as appellant number 8, the Nori Maji has been transferred and the said appellant has filed a separate interim application for bail by IA number 258 of 2025. He confines the prayer for bail in this interim application. He confines the prayer for bail in respect of appellants number 1 to 7, right? So who is appearing for appellant number 8?
Jenna.
Huh?
Nori Maji पे हम Jenna yes Jenna.
No, counsel को ना पूछो.
Yes Jenna.
Yes Jenna. ना appear कर चेटिंग.
Sir.
ताकि ना cause list तो असुनी.
Cause list तो अच्छी है.
Definitely cause list तो cause list अपन अपना रखना.
47/2.
जे जना जो
शैलो वाला जना
वो शैलो वाला जना
So for Nori Majeri concerned, there earlier there is an interim bill. The report has come out.
आइए नंबर से जो ये रे आओ बाकी स्पीकर ऑन ये सार्थक जो appellant को ना देखिले अपील मेमो को पढ़े सुन
Norimaji reject interim application type order dated.
Norimaji we are not considering because the counsel is not there. Now he is moving for bail of appellants number 1 to 7.
397/25 रे गोटे interim करथले that has been rejected.
So just a minute, appellant number 1 to 7
आगे
ଆପଣଙ୍କର ଆଗରୁ କୌଣସି ବେଲ୍ ଆପ୍ଲିକେସନ ରିଜେକ୍ଟ ହେଇଛି କି
ନାଇଁ ରିଜେକ୍ଟ ହେଇଛି
ପ୍ରଥମରୁ ଅର୍ଡର
ରହୁଛି only 1 ଆଉ 7 ଏଥିରେ interim bail ରେ ଯାଇଥିଲେ they have surrendered in due time.
ଟିକେ ବନ୍ଦ କହୁଛି 2021 ରେ
About 10/4/2023.
10/4/23 फिर see appellant number 8 ପାଇଁ Norimaji ପାଇଁ
No, that is the 7.
ହଁ 7 ପ୍ଲସ୍ ତାପରେ ଆଉ ଗୋଟେ ଅର୍ଡର ଅଛି ଦେଖନ୍ତୁ ସେଦିନ ଦିଟା ଅର୍ଡର ପାସ୍ ହେଇଛି ଅର୍ଡର ନମ୍ବର 12 ଆଉ ଅର୍ଡର ନମ୍ବର 13
Yes, Norimaji also.
ତାପରେ ପୁଣି appellant number 7 ପାଇଁ ସନ୍ତୋଷ ମାଝୀ ପାଇଁ ଅର୍ଡର ହେଲା interim bail on 8/8/2024 8 ପାଇଁ ବର୍ତ୍ତମାନ ଆମେ 1 to 7 1 ବି ଯାଇଛି ତ
sir 1 ଯାଇଛି 1 surrender କରିଛି 7 ଯାଇଛି 7 ବି surrender କରିଛି
ତାଙ୍କର ରିପୋର୍ଟ ଆଣନ୍ତୁ କଣ୍ଡକ୍ଟ କଣ ଥିଲା ଆଉ କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ଦିଟା ନିଆ ଲେଖନ୍ତୁ ଏ ଯୋଉ ଡାକିଲେ ନା ଲେଖିଲେ ନା ବର୍ତ୍ତମାନ ପ୍ରେୟାର କନଫାଇନ୍ସ ହଉଛି ଫର appellant number 1 to 7 it appears that appellant number 1 was directed to be released on bail by order dated 16/4/2025 है ना in IA number 3012 of 2024 for a period of 2 months and appellant I would have like appellant number 7 के बजाय इतना 7 का पूर्व and appellant number 7 was directed to be released on bail for a period of 12 weeks.
12 weeks.
As for order dated 8/8/24 in IA number 782 of 2022. ठीक तो? The Learning Council for the state shall obtain instruction regarding the conduct of appellant number 1 and 7. तो ना लिखी देवी. Appellant number 1 or 7. So also produce the custody certificate of all the appellants को दिए, है ना? Put up this matter कितना संगत सासी हो 246 संगत हो हाँ conduct लिखते ना हाँ conduct in inside jail also ना yes
Petition notice.
हम बुझिले कि से जो तार
One.
से जो तार मरी तमाम
मैं संतोष जी आईआईसी टाउन पीएस
फाइल नहीं मैं बाहर करना
they are not
1992 एक query the counsel you are the counsel
Yes, ma'am.
अपन कौन देइचंती जो डेथ हिसाब रे
Certificate issued by the councillor, Puri Municipal Council.
Puri Municipal Council
Page 6 of my.
What is your aberrament?
Para 3 lordship.
Para 3
Lordship.
ये आपण ऑलरेडी पठेई दैछन इंटीम आमे ऑर्डर टा पास कर दोछु जे जदी ता भितरे आसी गला आपण इंटीमेशन टा लगेई देबे लेखन subject to verification by trial court but in the meantime if जदी आपण पाई जानती इंस्ट्रक्शन टा then our verification दरकार ने will just try to get it by 4:30 है हां लेखन IN number so and so this is an application for interim bail of appellant Kapilo alias Kapilas Bhoi. He is the sole appellant.
Sole appellant in this.
On the ground that
Have you got it?
No.
Mother of the petitioner has died on 18/7/2025 and the presence of the petitioner is necessary for performing the obsequious ceremonies and certificate issued by the councillor, Ward number 2 of Puri Municipal Council is annexed to the interim application. Stop. Learning council for the data Jadisi pass for the later candidate. Learning council for the state submits that though instruction has been sought for from the concerned IAC, but he has not received the instruction so far. Jodi se pile, the instruction pile, so let us change kari hai likhe. The land council for the state has produced the written instruction received from the IAC council. Considering the submission made by the land council for the respective parties, the amendments taken in the interim application, the document annexed to the interim application, we are inclined to release the petitioner. Appeal for a period of 20 days from the date of release. Matter will issue on such and such day. The land council for the petitioner shall file the surrender certificate. While on interim bail, the petitioner shall not try to come in contact with any of the prosecution witnesses or the family members of the deceased and shall not indulge in any criminal activities. The inspector in charge of so and so shall keep a close watch over the activities of the petitioner while on interim bail. Violation of any terms and condition shall entail cancellation of bail. है ना? तापरे एटा लिखी देवे. Since subject to लिखिवे, subject to verification regarding the death of the mother of the appellant by the learned trial court through the concerned IAC. है ना? एटा को रखिवे ऐड करिवे. अब जल्दी से पाई जाती है भीतरे ताले एटा को भी काटी देवे और सेटा भी दरकार नहीं है ना.
Obligate.
This matter was not in the list, but on being mentioned that the petitioner's appellant's mother has died and an interim bail application has been filed, taking into account the urgency of the matter is listed by way of a special notice. Yes.
Item 13.
Report them over it on any
The report.
Yeah. ଆପଣ କଣ କୁହାଯାଇଥିଲା ଆପଣ କଣ ଆଣିଲେ ଆପଣ କୁହାଯାଇଥିଲା ଯୋଉ ଇଣ୍ଟ୍ରିମ୍ ବେଲରେ ସେ ଯାଇଥିଲା ତା କଣ୍ଡକ୍ଟ କଣ ହେଲା ସେଇଟାକୁ ଆଣିବା ପାଇଁ ଆପଣ ଏଇଟା ଆଣିଛନ୍ତି ଯେ the complainant and his family members are anticipating problem and he may take revenge against the family members of the complainant and if he is released on bail nobody would take confidence simply because in his bill objected to the release on bail. So is there any conduct that during the interim bail period se kichi tar sei bisare kuhaitala?
Let it come from other types.
Proper instruction କାଇଁ ଦଉନାହାନ୍ତି ତାକୁ ଅଲରେଡି ଆମେ 3 ମାସ ବେଲ ଦେଇଥିଲୁ ତ ସେଇ ଲେଟି କେସକୁ ରେଫର କରିକିନି ତା ଭିତରେ ତାର କଣ୍ଡକ୍ଟଟା କଣ ଆସିଲା ସିଏ ତାକୁ ଖାଲି କହୁଛି ଯେ ତାଙ୍କୁ ବେଲ ନ ଦିଆଯାଉ ମୋର ରିଭେଞ୍ଜ ନେବେ ସୋ ଏନି disturbance created by the petitioner during the interim bail period if that is not there then obviously the principle laid down in that leti case will that is their apprehension but the present scenario whether to bring another report
We can modify the conditions of the
the learning council for the state has produced the report dated 15/7/2025 of the IIC Balipada police station wherein though it is mentioned that the informant and its family members are anticipating problem that the petitioner may take revenge against the family members of the informant and objected to the release on bail, but there is nothing about the conduct of the petitioner during the interim bail period, which was granted as per the order of this court dated 1/7/24 in IA number 118 of 2020. The Learning Council for the state seeks for an adjournment till next week to obtain the report in consonance with the order dated 7/7/2025. Put up this matter. Next week, upon available 30th of July 2025. This report is taken on by the
Item 14.
The petitioner is in custody since more than 9 years.
ଆପଣଙ୍କର ଆଗରୁ ବେଲ୍ ଆପ୍ଲିକେସନ ରିଜେକ୍ଟ ହେଇଥିଲା ନା ଜାଣିନାହାନ୍ତି
20/4/22
20/4/22 ହଁ ରିଜେକ୍ଟ ହେଇଥିଲା ବର୍ତ୍ତମାନ ଆପଣ ଯୋଉ କହୁଛନ୍ତି 9 ବର୍ଷ ରହିଲାଣି ବୋଲି କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ଅଛି ଆପଣଙ୍କ ପାଖରେ
No.
Are you in possession of the custody certificate? Obtain that. Look, IA number 1865 of 2025. This is an application for bail. The Learning Council for the appellant petitioner submits that is in jail custody for about 9 years.
More than 9 years.
For more than 9 years.
6/2016.
ठीक है जी, for more than 9 years. Learning Council for the state for some time to obtain instructions regarding the criminal antecedent, if any, against the petitioner, is jail conduct, so also to produce the custody certificate. Put up this matter in the week commencing from 4th of August 2025.
Item 15.
May I please? When the appellant is in custody since date of his arrest manner on 4/6/2019.
आगु रिजेक्ट ହେଇଥିଲା
No, madam, this is the first application.
first time केबे रहलेनु
4/6/2019.
2019
Yes, sir.
6 वर्ष
6 वर्ष.
अच्छा ये डिपोजिशन कॉपी दे दी जंदी
That's it.
What is the offense?
Paperwork
is ready.
The offense is very. 302, Lordship.
The wife has been set fire by husband. Set fire.
Appellant is the husband, my lord, and deceased is the wife, my lord. Allegation against the husband.
For 397 of 2021, that is your stay of realization of fines.
Item 16.
May pages.
Yes, Dr. Nagor.
Yes, my lord. The petitioner in custody since 31st 10/15, my lord.
Single appellant.
Single appellant, my lord. Double murder case, my lord.
Bail reject ହେଇଛି?
Earlier, my lord, release on interim bail, thereafter a report call for my lord.
That report has some time to not yet often have contacted of the IAS concern.
कौन गोटे रिपोर्ट प्रोड्यूस करथिले गोटे कोन
Custody certificate.
Custody certificate. Can conduct of the petition while in an interim bail, you have to obtain that.
Somebody short time to read the judgment on your case.
My asset, my lord. Let
All right. So you have not received that?
Not received.
All right. The Land and Counsel for the state took some more time to obtain instruction. But what is this report dated 14? এটা ଗୋଟେ ଯୋଉ ଲେଖା ହେଇଯାଇଛି 5/11/2024 ରେ ଏଟା କଣ wrongly mention ହେଇଛି ନା କଣ? The Land and Counsel for the state has produced the report obtained from IIC Bheden Police Station dated 14/10/2024, which indicates that there is nothing adverse against the accused petitioner Ramo Patra. The report be tagged to record. Kahin se record legi? ଆଗରୁ ଗୋଟେ ରିପୋର୍ଟ ଆସିଥିଲା ଭଳିଆ ଲାଗୁଛି ଏତେ କଥା ଆମେ ଲେଖିଛୁ ମାନେ ଥିବ ଗୋଟେ ଏଇଠି ଅଛି ପୁରା ରିପୋର୍ଟ ଅଛି ସେ କେବେ ଯାଇଥିଲା
5/1/2023 for a period of 2 weeks.
ତାପରେ ସେ ଆସିଛି ରିପୋର୍ଟ
Maybe that the below of the flag see in custody certificate there is a report attached.
Yes, custody certificate ତଳେ ଅଛି
custody certificate ତଳେ
reference to the above that is service
no case is made out କେତେ ମାସ ଯାଇଥିଲେ ଆପଣ
15 days.
15 days ମାନେ litigation ଦେଇ ଯାଇନାହାନ୍ତି
No, ma'am.
3 ମାସ Heard the Land and Counsel for the petitioner, Land and Counsel for the state. The Land and Counsel for the petitioner submit that the petitioner is in judicial custody for more than 10 years.
Near about 10 years.
Near
October have a period 10 years.
नहीं ये जो 28/2024 कस्टडी सर्टिफिकेट टा अछि
wrongly से देही
नहीं 9 वर्ष 7 मास
हिसाब करी कलर को पड़ी जाउछि कारण एटा 23/2024 से बहुत दिन रॉन्गली रिपोर्ट है
से देतले स्टेट काउंसिल से ठीक न
स्टेट काउंसिल माने देइजन माने तम आपण बोले ऑन रेमिशन टा हिसाब करना आपण एक्चुअल कस्टडी को ये करछन there is a column in that on remission, so that is also
remission is included. Therefore,
no sethi bhi hisab
actual custody plus remission.
Actual custody का और remission को include कले 10 years से
including remission.
हाँ, let go. ठीक है. For 10 years, including the period of earned remission, है ना? And which will be evident from the custody certificate produced by the custody certificate produced by the state from Superintendent of District Jail Balgad dated 23/9/2024. The Land and Counsel for the state has also received instruction that during the interim bail period, no case was instituted against the petitioner, and from the verification of the case record, and nothing adverse was found against him except this case from the verification of the case record in the said police station. Stop. Considering the period of detention of the petitioner in judicial custody, in view of the available material on record, while not inclining to release the petitioner on bail on merit, but taking into account the period of detention in judicial custody and it of the leti case applicable about 3 years, and keeping in view the principle laid down in the case of leti versus so and so 3 months bail transfer.
My appearance may be recorded. The informant.
Mr. Vijay Kumar Mishra, Land Counsel for the informant is present. Yes, ma'am.
Item 17.
Item 17 on behalf of Maharashtra, my lord, can I take some author name?
Mention is made on behalf of Mr. B.B. Rautray for adjournment. Please this matter. Adjourn pertain. Yes.
Item 18.
May I read?
Yeah.
Notice already solved, my lord.
Notice ପାଇଁ ଯାଇଥିଲା କଣ ପାଇଁ?
Pokso.
ପୋକ୍ସୋ ଥିଲା। କଣ ହେଲା କି appear କଲେ?
The special mention item. They have given a WhatsApp in this manner.
Local concerning that the mother of the petitioner so and so named as expert on so and so regards IS. ठीक आपण इटा को ये कर दियो सिग्नेचर कर दियो तो ହେଲା
IIC ର WhatsApp ରେ
ठीक ଅଛି କିଛି ଅସୁବିଧା ନାହିଁ ସିଗ୍ନେଚର କରି ଡେଟ୍ ପକେଇ ଦିଅ ତାଙ୍କର ସେ ଆପଣ ନି अच्छा
लिखि दियନ୍ତୁ received in my WhatsApp
हां लिख दियो
from IIC तुम सेंड कर
हम सेटा काटी देले the land council for the state has produced the WhatsApp message received from the IIC in which it is mentioned that the mother of the petitioner has expired. Does it date the issue?
18 केते
18/7/25
on the
that corroborated the petition.
So and so है ना the said message is taken on before है ना तापर सीधा बिल दे देबे 20 दिन और वेरिफिकेशन करिया से पोर्शन टाउ काटी देबा अजे इटा दी शीघ्र कर देला हां
Item 19.
तो मीटिंग अमूल चौक उठा
item 13 ना को हां फोन बाहर ना कंप्यूटर
এটা মিশ্র উইল জাস্ট কেবে ভবনী বাহাগর সেই যে মেনশন দাদা
mention
is nobody oh when the marriage is
The marriage is on first.
first August
Copy may be.
give it a copy so that it can be taken up day after tomorrow हाँ you solve one another इधर लिखी नहीं item number 30 रे IN number ये जो 1955 तो 1955 of 25 is an application जो हमसे बाहर कौन item 30 no IN number to hard one 1955 is an application for bail filed by appellant number 1 S. Balaji Acharya for grant of interim bail on the ground of his younger sister's marriage, which is fixed to 1/8/2025. The relevant documents and wedding invitation card has annexed to the interim application. The land council for the state took some time has received the copy of the interim file. Please give it. We are mentioning that you have handed over. Please hand over immediately. Let a copy of the interim application be handed over to the land council for the state in court today. We will obtain necessary instruction in that respect. Put up this matter on 25th of July 2025. Right? So that is item 30. So CC yes, now serially the
Item 19.
Here were two appellants are there, no?
Application for bail, I may allow to take the extract of the deposition.
it a regular bail. आगुर रिजेक्ट ही नहीं है
Yes.
तो बिल देना दी जो डिपोजिशन कॉपी
Deposition copy ମୁଁ ଦେଇଦେବୁ ଉପରେ ବକ୍ସି ଯେ
दे दो ना
next week as
लिखो the IN number so and so for bail land council for the petitioner shall solve the deposition copies of all the witnesses examined in the trial court and trial court to the land council for the state by tomorrow लिख दो
ସେ deposition copy ଗୁଡ଼ା ମୁଁ ଆଜ୍ଞା ମାର୍କ କରିଦେଇଛି ସାର୍
अच्छा ताले गोटे काम करंतु पेन ड्राइव रे नहीं जानतो आपण ट्रायल कोर्ट रेकॉर्ड पड़े आइछ ना अच्छा लैंड काउंसिल पर लिख दो लैंड काउंसिल फॉर द स्टेट सबमिट्स
वो केस को मार्क करछि प्रोसीड्यूरल केस मार्क करछि बोलो କଥା
नहीं ठीक अछि आपण नहीं जाओ ये not having the deposition copy. But it is ये copy अपन पर जोड़ा अच्छी कौन certified copy
copy रे
mark कर दीजिए
एक हदो देखु ना मार
ना ठीक it's all right let the
distance हो गया नहीं वो बोले सब काढ़ी रखती हो
let the copies of the learning counsel for the state be permitted to take the deposition copies of the witnesses in his pen drive from the soft copy of the trial court record. आज ही नहीं है not just trial matter पड़े and matter be placed next week कर दूँगा. हाँ.
Item 20.
Similar earlier bail application are rejected. In the present bail application, that is IA number 3349 of 2024, I have mentioned that Miller in para 3. That was rejected on 18/7/2024. The present appellant was on bail.
अपन deposition copy देइथिले
He was on bail during trial and now custody about 5 years and 9 months.
Offense 302.
302 life.
Direct evidence अच्छी.
No direct evidence, but on the basis of circumstantial evidence.
What are the circumstances?
Well, that is the background of the case is that the deceased is the second wife of the present appellant Miller, and here while the petitioner, the appellant was taking the dead body of the deceased in an ambulance, he was Miller detained by the police, and thereafter a UD case has been registered, and thereafter it was converted to FIR. And so far as the death is concerned, the deposition one, the inmate of the house.
PM doctor was conducted the autopsy as opined. Cause of death was due to asphyxia as a result of
constriction,
compression of neck, and the deceased was pregnant.
9 months.
Carrying a male dead fetus of 8 months gestation.
Yes.
So that doctor has been examined as PW 28 hours.
And one inmate of that house where the death was Miller caused, he was examined at PW 8. That is sorry, PW 11, Padmavati Pradhan. By the time the death was caused, she was present at the house and did the first wife of the appellant. And she stated that the Lordship may kindly come to deposition of PW 11.
No, you see, no question of homicidal, suicidal death. You see is it your case that it is a case of suicide?
It's not Miller. So somebody compressed the neck of the.
So somebody means who?
Well,
who is that somebody?
By the
your
time,
wife.
By the
you
time,
are saying.
By the time the death was caused, I was outside. This is the statement of PW1. I had gone to call a auto rickshaw. PW in para 2, the deceased died on, I am reading out Miller. Deceased died on
20 चिपिकी मारी तापरे मोटर रिक्शा को डाकिया को आनी किनी एम्बुलेंस रे ले गले कोन आपन करो येटा ऑफेंस टा कमी जीवन ना कोन
that happened Miller, he was on bail during trial.
Maybe on bail. Now you have been found guilty, and how do you meet it unless you overcome the evidence of the doctor? And you are not disputing that she was in your house, she was your wife, she was in your house when the occurrence took place.
And let it be lie over Miller. After some days.
After puja holiday, Shukla puja holiday. बाकी थोड़ा सा ऐड कर देंगे शुक्रवार है ना